Yo, what's up, y'all? Welcome to the docket presented by Defense Diaries. I am your host, Bob Mata. It's just me solo. Allie is still, believe it or not, working on that nightmarish post-conviction relief act petition that has been now going on for 3 weeks. Like all of our Avery listeners on the podcast are freaking out because we haven't made one in like a month. I can't drag her out of it. So I mean that's just on hold until that particular document is finished. She's working very hard, like 18 hours a day. So I probably could have stolen her for this, but she offered, but I know she just wants to get that thing done. So welcome y'all. I really wanted to kind of to stream this thing. I wasn't even necessarily aware that it was going on because I try to avoid um politics in general, just because they freak me out. I'm extremely freaked out about the 2024 elections, and then I was on Law and Crime yesterday, and they were covering it, and it became pretty evident that it was like must-watch TV. And for y'all that don't know what's going on with this thing, obviously, the state of Georgia, through Fani Willis, who's the gal who is the subject of this hearing. She is the district attorney down there, and she is the one who brought the case, the RICO case against Trump. For all the things that were going on after the election, where he was, especially in Georgia, where he was claiming that they had thrown the election and all that stuff. Ultimately, she ended up bringing a pretty heavy duty case against him and a lot of his homies, and Trump's lawyers then turned around and started digging. And what they ended up discovering is that the one of the special prosecutors that she appointed to the case, that he was actually in a romantic relationship with her. Rachel, we just dropped the Garcia 50 on Patreon. So if you're dying to hear it that much, join Patreon and then you can hear it. Otherwise, you'll have to wait a day. I think we're going to drop it on the normal feed tomorrow because I've been keeping you all waiting on that stuff. So yeah, Garcia's out in the world, at least on Patreon right now. Also, if you guys didn't hear, I did an episode with Susan and Jacinda of Proof. Susan's an unbelievable wrongful conviction attorney who has done amazing work. I'm a huge fan of hers. Yeah, y'all, I am actually where I record my podcast. This is like my actual studio. I've got my two giant Thunderbolts. This is the first time I've done it down here. So hopefully the sound is good. Sound should be better because I'm using my real mic as opposed to my little baby Shure that I always use when I'm upstairs. So all right, but I want to give you the layout. So essentially, what Trump's lawyers are suggesting happened is that Willis hired the special prosecutor, and that they were in a romantic relationship. And Trump's people are alleging that she hired him in order to be able to financially benefit from the fact that she hired him to be a special prosecutor. So, by way of trying to show that, they've been trying to put on evidence that, we have movement in the courtroom, that, he was paying for plane tickets, he was paying for trips, because the appearance of impropriety in that particular circumstance is not good. So I mean, we're definitely late to the game on this. I wish I would have known. I would have been streaming it yesterday, but I would have had to jump off anyway because I was on Law and Crime. So yesterday she testified. She was very combative, and this thing is like, and I'm not going to get into the politics, y'all. Like that is not something I'm going to be doing. Like that's not my game. I'm strictly going to be dealing with the legal side of this. I am not. I don't deal with politics on my show. And if y'all are gonna, start getting into the political debate on the stream in the chat, I'm going to warn you now, if it gets ugly, I'm going to have the mods dump you. You know, this isn't the place for that. This is an interesting, very interesting hearing. There's no denying the fact that the politics are obviously intertwined with this. You know, I mean, there's a camp that, you know, especially Trump and his people are like, look, this is politics. You know, like this isn't, I didn't break any laws. They're trying to stop me from being able to run again in 2024. And, you know, I mean, if you're looking at it objectively, there's some truth to that. Like, I mean, politics, you know, I mean, it's running things. So, but yeah, stay classy in here. Like, cause I know, believe me, we all lived through 4 years of Trump as president, and it was the most toxic period of time on social media that I've ever seen in my entire life. And I'm not bringing that to this. This is not what this is. This is not a platform for people to start getting into huge political debates. Let's just keep it about the hearing, and let's just keep it cool. All right. You guys can do it. I know you can do it. I do it all the time. You guys wouldn't believe how much shit people give me sometimes. And I never pop off. I never pop off. I'm always cool, man.
That I do remember at some point it was
All right.
myself, you,
Sounds like
BC,
we're on.
and Bert there, but people were
Can y'all hear it?
in and out of the courtroom, so I cannot sit here and accurately say that somebody else wasn't there at the time.
We talked, I mean, and people could have come and gone, but essentially
Correct.
we talked about an hour.
No, it wasn't an hour.
And that's the only time we spoke in person about anything related to this matter, correct?
Correct.
And based on that phone conversation, I told you I had been submitting open records requests and I was going to continue to submit open records requests, correct?
Based off what phone conversation?
On our conversation in court.
Oh, okay. Correct. You said that you were doing some open records requests, correct?
And then based on our conversation, I told you I was going to do some additional open records.
Which open records request are you talking about?
The same one, that's when we talked about that I was going to be doing some follow-up. It's what we have.
Because I recall open records requests being made for other things, and so I don't know which one that you're referring to.
At that time, we talked about getting, I guess that's called a county card and getting access cards and things like that.
Is there an echo? Yeah, it's weird.
Okay. And yes. And you asked me if I have an access card.
And you are the one that told me that you and Mr. Wade, or Mr. Wade had access card.
I told you that the three of us had an access card because we had a contract with the
Does that get rid of the echo?
County. I told you what those contracts were, and that we had an access card that will allow us to pick up the documents, go into a specific office, and leave out.
Okay. And so we talked about that badge access card and asking for that, but I was going to ask for that, right?
Correct.
And then a couple days later, I sent you a text, and then when I say a couple days, so that was on September 12th when we had that conversation.
Do you mind if I pull out my phone?
On September 14th at 6:38 p.m.
And what day was this?
It was September 14th.
September 14th, correct.
And I sent you a screenshot of a Fulton County opening records request I did.
Yes, and I said, wow.
And then we continued to text.
Wait.
All right,
And you
I'll
sent
be right
another
back.
text about a badge, and I did not respond. You sent another text about an entrance card. I did not respond. You sent another text about some other badges and with the circle around it, and I did not respond.
Okay.
That's right, thank you.
All right. Mr. Bradley, if you could just respond to the question asked and only the question asked.
That was
Thank you, sir.
actually, I have an additional.
Okay.
Thing I want to raise. Ms. Merchant provided some text messages that she let us know that she was going to refer to. The text messages are inconsistent with Mr. Bradley's exchange as he apparently is reading it off of his phone. So if I could ask Ms. Merchant, is this it is true, accurate, and complete? And perhaps we can see what's on Mr. Bradley's phone. But more importantly, I am going to object. I understand the court's leeway about Ms. Merchant
Sure.
being able to establish contact based on previous statements made. But I'm concerned about going into the content of the statements without putting things in the buckets that I don't.
Sure. And so am I, Ms. Merchant. I'm not seeing so much the relevance of it back and forth. I'm allowing you to establish, the contact that was made and line with the outline you provided me. And I think we're on track with that. Were you planning to tender these text messages?
I was planning on discussing them with him. Now, if yesterday he said we didn't text about this case, so that was his testimony again today, then yes, I will at least show them to him to refresh his recollection or to impeach him. But Judge, their first part of their argument is foundation, is what I'm assuming. They're saying all of these. They're not all relevant. I can give you all of my texts, but they're not all relevant. And so they asked for screenshots, and so I took screenshots. If there is a way to submit my entire text history to Mr. Bradley, then that's fine. If they want us to read every single text, that's fine. I just don't want to be in a position where people are saying that I'm not.
Well, I also want to avoid the situation where you as counsel of record are having to lay the foundation and do that sort of thing yourself. So I don't know how much further we can go with this before we get into that. So.
Well, I'm not sure what their objection is. So I asked him about one question and he read
Sure.
out several.
Why don't we just go with your next question and we'll see where we go from there.
All right.
But so, and
Bradley, when you wait for her to ask a question.
I understand that, Judge, and I'm not
Well,
trying to
apparently you don't, sir. Wait for her to ask a question and you'll have a chance.
So I think what the last thing I asked you was about September 14th. So those texts that you're talking about, those refer to the issue that we're here today about them.
Some text did, yes.
Yes. Okay. And then you called me again on September 15th, 2023, and you spoke on the phone.
I do not recall that.
What's up, wild child?
That I needed to call you back, and then I later called you back.
I'm not sure. I do not recall.
You don't recall that? Okay. And if you recall the following Monday, Your Honor, I appreciate the question as it is on the form. And if the question is what she's going to read, I object to it even being asked out loud without knowing number one, the relevance of it. If the witness is going to answer the source of information, and I feel like it is so inflammatory as to say out loud without knowing where Mr. Bradley falls on that, then I do have an objection to the question.
Okay.
I'd
All right.
rather ask it.
Oh, sorry to hear that, Wild.
Why is it that we're not allowed to ask a question? And then when the question is asked, there's an objection made either by the state or the lawyers for this particular witness. It appears that what the state would like to do is force us to tell you in advance every question we're going to ask before there's an objection raised. And I don't understand why they get to do that when we are obviously in the same position to say to them, tell us every question you're going to ask first. I realize it's a privilege, but that can be the questions asked, state objects, chauffeur objects, and the court rules, but not being able to put it on the record because it's inflammatory or it's somehow prejudicial. I don't think that, I'm just suggesting.
Sure. So, Mr. State, I'd agree with you in the general sense of things, but in this situation, Ms. Merchant offered to provide essentially her list of questions in advance, giving us a preview of what she's going to say. And that puts us in kind of a different posture in that respect, where we can actually have some sense of what's going to come out. But Ms. Merchant, I think knowing what your next question may be, since usually we don't have that opportunity, does it presuppose some knowledge on his part that we have yet to establish is inside or outside of privilege?
Well, the first thing, Judge, is I gave these questions so that you wouldn't be in a situation
Sure.
where you were objecting and having four different lawyers talk about. privilege, confidentiality, every single question. So I was hoping that we would ferret that out ahead of time. So this is the first that I've heard that objection to question 18. I think the state copies of as well. Trying to be completely transparent. I also, I have to establish that his information, there have been statements in this court that I lied, multiple statements yesterday. I can't even tell you how many times that was said under oath yesterday, and that I did not get this information. And so I have a right to
which I've already said we can do and we can go over, but and we've already started doing that. But the next question, as you plan to ask it, may presuppose again some information that he has that we need to determine whether it's inside or outside of privilege. Is that right?
No. Well, I don't believe so. No. I mean, if we're going to talk about the privilege, I wanted to talk about it beforehand, which is why I gave all of these. I didn't know the state had objections on these questions. Privilege. If we're going to talk about the privilege, I'm happy to ask him the substance of the question, but that is what I'm getting objections for. So I'm trying very carefully to craft something to avoid that. But I'm happy to just ask outright the question.
Right. I don't see a way around that, Ms. Cross.
I understand, Your Honor, I'm going to do what I'm trying to do. The problem in the context that Ms. Merchant is posing the question is, this was our communication, this is what I asked you, this is what you told me, and here are these texts that are supporting it. I understand the court's ruling that based on how things have gone, if Ms. Merchant feels like she needs to establish there was contact and communication, then I don't have an objection to that. However, number one, the text message that exchange that Ms. Merchant gave me is apparently not complete. And so I don't know, without making her a witness, how the state can, and we're entitled to, if you can refer to text messages, we're entitled to an accurate representation of what those are. Mr. Crowley's looking at his phone, and that's what he's got. He is under no obligation. Ms. Merchant provided this to us, and I appreciate it. But I can't tell as I'm sitting here to object to an incomplete or an inaccurate recitation if what she gave me is incomplete.
So a couple things come to mind. One would be that anything the witness is referring to on the stand, counsel at any point has the right to inspect. And so if that's what you're asking for, Ms. Cross, then I think you have a right to do that if you decided to do that. The other is as I've seen it so far, I don't think these texts are coming in as substantive evidence, but more for impeachment, in which case extrinsic evidence would never be coming in to prove them up. And he either takes her answer or he doesn't. That's how it works. So I don't see the foundation issue or the completeness issue really playing into it as it comes to impeachment.
And so they asked me for the relevance for instance. I took them. He doesn't have an iPhone. I can't download the entire text message history. I told him they could go through my phone. Like, I'm hiding something.
All right, Ms. Merchant. I think at this point, again, I don't see anything extravagant about the next question on his face. I think we need to deal with it as it goes, so you can proceed.
I asked you where I could get an affidavit from about the affair, and you responded no, because you didn't think anybody would freely burn that bridge. Isn't that true?
If you say so. I mean, I don't.
You have your text if you need to refresh your memory. September 18th at 3:11 p.m.
Can you repeat the question?
The question is, did I text you asking you if you knew who I could get an affidavit from about the affair? And you responded no. No one would freely burn that bridge.
Yes, I do see that.
Then I asked you if Chris Campbell did it, correct?
No, you asked me if under oath he would testify.
Your Honor, again, I'm going to object to the source of the witness's information about that, whether that's firsthand information or not. And Mr. Campbell, of course, has a privilege too.
Well, since Mr. Campbell hadn't even been brought in to this proceeding at all, I'm also wondering about just the relevance of asking questions about Mr. Campbell.
It's been objected that I'm not asking about all the texts and I'm selectively asking, so I'm trying to go through all of them. I would much rather just ask the very relevant ones.
Well, I have an objection to her asking. I can't tell if the statements or the testimony provided is consistent or inconsistent without a complete set of this text exchange. And it's not clear in the text exchange what the source of Mr. Bradley's information that he's providing is. And so that is, I'm
Sure.
struggling, and I know everybody else.
And again, I think you're focusing more on the merits than the impeachment value, right? If the sole purpose this is coming in is under those grounds, then you being able to match them up word for word, I don't see that as being a necessary prerequisite. But as it relates to Mr. Campbell, he's not a witness yet. He hasn't come in. I don't think he's come up really at all other than passing and maybe the firm. So why don't we skip ahead to the next questions, and you could always come back to that if somehow he is made an issue in this case.
That's great, Judge. I needed some clarity because the state is objecting that it's not full and accurate. I'm keeping things out, and then they're objecting that I'm putting too much in. So I'm just trying to avoid every question having an objection, Judge. So on January 5th, 2024, we had a text exchange where we talked about that I had discovered that Nathan took Fani on a cruise and a trip and paid for it with the business card. You told me you were on a plane home from Dubai, but you would call me as soon as you got home. Do you remember that?
So what I have is a text message from you saying, "Oh my God, Nathan took Fani on a trip to Napa and paid for it with his firm."
Okay, continue reading.
And you said, "Is he that dumb?"
Mhm.
And I said, "Wow, I'm on a plane from Dubai, land at 3. We'll call you as soon as I land."
So that is accurate. That's what you told me.
That I will call you as soon as I land, and wow.
Yes.
Yes, that is accurate.
And then you told me that you weren't surprised because they took many trips to Florida, Texas, and California.
Okay, so I don't have that, but and I can show my phone, but I don't have that in my phone.
So the question is just, do you recall
I do not recall.
communicating that to
I
me?
do not recall.
All right.
Do you recall telling me that it was when she had to move her daughter, a trip to California?
I do not recall that.
And Judge, may I approach the witness?
You may.
Thank you.
Oh, I see.
See if that refreshes your memory.
Yes, I see this.
Does that look like, does it refresh your memory?
It does not. I mean, I see what's on the text chain, but you said this happened January 5th?
I can tell you exactly when it happened. There's no date and time stamp on that. Let's see. It was, let's see, it was I believe it was January 5th. But just give me one
Judge,
second.
I just want to, on behalf of Mr. Wayne, just to review the section again. We still don't.
To which question?
To the current question, we still don't know the source of this information, whether it was privileged or how he obtained it.
I'm wondering now if there's a timeliness issue on your objection, since he already, well, he said he doesn't recall. So
Right,
there's,
he just gave the date. He didn't
sure.
start answering.
Well, his question or his answer was he doesn't recall and his memory has not been refreshed. So I think it's time for the next question.
May I approach the witness?
Okay.
Can I see what you're approaching the witness with? So is this the complete text chain?
Yeah, it's a complete text.
Thanks, Fofa.
While they're looking at that, can I just ask you, did you delete any text messages?
I have several messages in the phone with you. I've never deleted. I mean, there are messages about family and my health and things like that. You asked me to be on some panel.
Yes.
And so I think it's complete, but
Well, no, my question was, did you delete any
no,
text?
I haven't deleted anything. No,
Okay.
I have not.
And I offered them to look through my phone earlier if they are welcome to.
We never provided it to us.
Said you,
The physical phone, you never provided it to us.
it's the only phone I have, Judge.
Yeah. I understand, and I don't want to keep popping up, but my concern, of course, is that these exchanges are just two lawyers gossiping about information. And
No, this is not the boyfriend. Nathan Wade
I understand
is the boyfriend, and he was appointed as a special prosecutor
do it in a way
by
that the substance
Fani
of
Willis. That's what the issue is.
is not.
It's not the
that
issue that they had sex or they were in a sexual
That
relationship.
part is
It's the issue is whether or not, because of that
I don't think we've
appointment,
gotten to
if
that
she was
point
gaining
quite yet in this
financial
process, but you can renew your
benefits
objection if you
by
think we have.
hiring
So right
him
now,
from the
sole
money
thing
he
that
was
Ms.
getting
Merchant is
paid to
trying
be a
do is
special
hand an
prosecutor,
object to
they're
refresh
trying
his
to show that
recollection
he was
again.
paying for
So we'll
trips,
see where we get with that.
dinners, that she was getting all kind of financial benefits
And I don't
by
have
appointing
that.
him to that job. And it's tricky because, I mean, obviously the guy
Mr. Shada.
makes his own money other than just being a special prosecutor.
You're going to be able to determine whether something that has come in, if you choose to, is hearsay, whether it's admissible, whether it's relevant, whether it's impeachment. You're in a position that if it all comes in, but you reserve the right, or all parties reserve the right to object, we can deal with it. This is not a jury. We don't have to worry about the jury hearing something that it will no longer consider. All we're doing now, with all due respect, and I understand there's a process. The state doesn't want something to be heard.
I object to that.
They've repeatedly attempted to stop questioning. Your Honor can hear it all and then decide what is and is not relevant or admissible. We don't have to go through every single one of these. The only time you have to go through this is if it is in fact a communication and it's a privileged communication, and an argument has to be made at that point as to whether or not it should be elicited or it is subject to being stated in open court. Otherwise, all of this could come to the court, and the court can then decide how it wants to treat it. That's
All right. I appreciate that, Mr. Sadon. I think it's certainly accurate that we could have an approach where if it's a close toss-up on an evidentiary question, we can have it all come in and sort it out later on the record. I don't think we've quite reached the point where I need to do that. I think we still have time to get into these, and it'd be my preference to keep the record as clean as possible and without questionable evidentiary issues. But we may get to that point. So the question from Ms. Merchant was to approach the witness and with an object to see if that would refresh his recollection to the last question asked.
Yes. Now, I'm sorry, the state scrolled through it, so it's not right there again.
We will time you out. We will time. I gave you all a warning. This isn't going to become a political debate in here. Let's just watch this hearing, see what shakes out. People can't play nice when it comes to politics. So there's a dispute. Both.
Now I can't find it. So I'm going to move on to the next question that I actually can find, and then I'll find that and come back to it. I sent you a statement and said, upon information,
But both Nathan Wade and Fani Willis claimed that the relationship didn't start until 2022, but they put a witness on yesterday that said that it started in 2019.
I think
So,
that's
and
fair.
everybody was under
Is that
oath.
based on your personal knowledge?
But what question, was it municipal court or when they first met, or?
My question was, is this accurate? Upon information and belief, Willis and Wade met while both were serving as magistrate judges and began a romantic relationship at that time. And you wrote, no, that it was municipal court.
Okay.
So I answer.
Barely just a second. Mr. Chopra has risen.
All right, Your Honor, I do have one.
Listen to Mandy.
Here, and that purpose has now been met. Any information
We will
Mr.
boot
Bradley
you.
may possess would in fact have come from his representation of Mr. Wade. This falls within the purview of his divorce proceedings, which, as we testified earlier, commenced in December of 2018. There's no Pierce or Shield associated with it, and so we would say that under Rule 1.6, we should not be compelled to give any further information.
Okay, and as we discussed about before the break, Mr. Chopra, if I ruled earlier this morning that this witness is going to be directed to respond to any question to the extent it falls outside of attorney-client privilege and only attorney-client privilege, meaning 1.6 is not going to bar his testimony in this case, what would be your response then?
Then Mr. Bradley would have to consistently assess on his own, unless I'm jumping up and objecting for him, whether or not this came within his knowledge based on his representation. Now, I can say based on the phrasing of the question from Ms. Merchant, it would in fact come within information obtained from his partner client at the time associated with the activity.
Yes, Dr. Bull. This is to DQ
Mr. Evans.
Willis and also
Hey, Mr.
a motion to dismiss, but this hearing is relating to the motion to DQ her.
Separated out, but it's still based, we just review the objection that it's still based on gossip, either gossip or privileged communication. He doesn't ever cite the source of where any of this information is coming from, so I just wanted to make that objection.
Okay.
Judge, as far as privilege, any privilege objection, it's been waived, particularly for this issue because Mr. Wade
You did testify on this subject.
testified on this subject.
Well, he didn't testify as a communication with his attorney about any subject. He testified factually about what trips he took and events that occurred. He didn't testify, to my recollection, about any communication with his attorney.
But he testified about the subject matter of the question that was just asked, which was when apparently they first met.
Furthermore, Judge, my client wasn't privy to that testimony. We have been under subpoena and therefore under the rules, so we do not know what was or was not
Sure.
testified to. Everything he says would be a violation of that privilege unless we know specifically what all has been waived.
Sure. Unless I make a finding that there was an express waiver on behalf of the client.
Per
Yes.
question.
Okay.
And
Sure. Got it.
So
All
for
right.
this question particularly, Judge, we would ask that you find that there has been a waiver of the attorney-client privilege because Mr. Wade testified to something directly different than what this witness, we believe, has
Okay.
knowledge of.
Ms. Cross?
Yeah, so Mr. Wade testified as to when they met. That is not the entire substance of the text message that Ms.
And began a romantic relationship.
Yes, he did not testify that they
Okay.
were serving as magistrate judges when they began a romantic relationship.
All
He
right.
testified differently.
Okay, Ms. Merchant, I think you're going to need to establish whether this witness ever gained that knowledge independently or during the course of a attorney-client relationship.
Did
He
you have
gone.
any, thinking back to the source of your knowledge, and let me just, before I do that, let me remind you of what is covered by attorney-client privilege. It's communications that relate to matters in which legal advice is sought and communications that have been maintained in confidence and no exceptions to the privilege. So it's communications that are in furtherance of legal advice. Your knowledge that their affair began, that their romantic relationship, began while they were both serving as municipal court judges. Is that from your personal information, your personal knowledge, or is that from?
I'm going to overrule that objection, Mr. Chopra. He can answer that question.
State that question again.
Your knowledge,
Is any knowledge, if any,
if any knowledge, of Nathan Wade and Fani Willis's relationship, romantic relationship beginning while they were both serving as judges, is any knowledge that you have from your own personal knowledge or something that was told to you in furtherance of legal advice?
I have no personal knowledge of when it actually happened. I was not there. I do not have any personal knowledge, so
Okay.
I would choose not to answer that question under 1.6.
Mr. Bradley, we made a distinction earlier
Yes, sir.
that it's a bit narrower than that.
Okay.
1.6 is.
I have no personal knowledge, Judge. I apologize.
Okay.
If you were,
That's not a problem. The issue is attorney-client privilege. And so whether what you learned, if anything, was during communications with the client.
It was.
Okay. Ms. Merchant.
and was it any knowledge that you had as to the truth of that statement? Was it told to you in furtherance of legal advice?
I'm going to object to that. If that statement is true,
That's how I.
and the witness has already testified, he has no personal knowledge about that. So whether he represented at one point it was true or not true, he has no personal knowledge about that, so could not testify.
Prior inconsistent statement, Judge. Do it all the time. That is what the state does
It's not a
regularly.
statement.
They bring in, if it's a prior inconsistent statement of another witness, Judge. Mr. Wade
Which other
testified.
witness?
I'm
Okay.
sorry.
Okay, Mr. Wade testified.
That their relationship did not start.
But you can't impeach him with a prior inconsistent statement that's privileged. And so we haven't gotten over the privilege hurdle.
Thank you, Trinity, for that $2
privilege
holla.
hurdle We've gotten over with fraud on this instance.
Well, that's the first time you use that word. So if you want to make the argument of why that applies, you can do that now.
Yes, Judge, the crime fraud exception, it applies because of the crime fraud exception.
Which crime and or fraud was committed here?
So there's a couple different things, and I want to just address them both because he's raised 1.6 and also raised attorney-client privilege. For the crime fraud exception says the privilege doesn't apply if it's if the existence of it, essentially if he has to keep something secret to allow a fraud upon the court to continue. So we've got that. We've also got
No, it has to, the legal communications have to have done in furtherance of a crime or fraud. How has that been established? And what crime or fraud are we talking about?
we're talking about perjury, lying to the court.
In the affidavit filed last month.
Yes.
And so what have you done to link the communications that he made maybe, I don't know, years ago to the affidavit filed last month?
The communications he made years ago, it's proof of the affidavit being incorrect, being false. He's given a prior inconsistent
But the
statement.
legal communication has to be in furtherance of a crime or fraud.
Right, but he also can't protect. So, and I think it's more under.
But if he had no idea, an affidavit wasn't even going to need to be filed until a month ago.
Right.
And these communications and everything happened well before that. How is anything that they communicated in furtherance of that affidavit that they didn't even know would have to be filed one day?
It's been waived. That part's been waived because he filed the affidavit. So you can't file something that's false and then your lawyer know that it's false and then say, oh, well, privilege, my lawyer can't correct that. When he waives the privilege, and he waived the privilege. He testified about this yesterday.
Okay, Ms. Cross.
I don't think that's even close to an accurate representation of what the law in this area is. And beyond the real kind of throwing out fraud and this and
Wow.
that, which
The Rockaways.
you have, Your Honor, is a conflict in the evidence at this point. I know which way the weight of the evidence appears to me that that's going to be for the court to judge, but conflict in the evidence, that is not a crime. That is not a fraud. That is not perjury. That's a conflict in the evidence for the court to decide.
So I agree with you there that you would have to first establish a crime or fraud occurred by preponderance. Got it. And anything else?
Just that she can't, under the guise of impeachment of this witness, number one, establish that. Number two, the witness has already said he doesn't have any personal knowledge of that. And there is the kind of specificity that is required to lay the predicate for a crime fraud exception to the attorney-client privilege is nowhere close to being met here.
Okay. Anyone else want to be heard? Mr. Sada.
Yes, Your Honor. This is what I said to the court earlier. This is not crime fraud. The scenario in the case I said, you want me to cite it for the record?
We go for it.
Okay. It's Owens Corning Fiberglass Corporation versus American Centennial Insurance Company et al. And it is 660 Northeast 2nd, 812, out of the state of Ohio, Lucas County, Court of Common Pleas of Ohio. And it references, I'll make sure I get the right page here. I think it's page 256. point in the case, or the holding in the case, if the party or witness chooses to testify falsely, and our position is that Mr. Wade testified falsely when he claimed the relationship.
Wow.
did not begin until 2022.
That was yesterday, the Rockaways.
There are attorney-client communications in which the same individual witness has told his attorney something contrary to that, inconsistent with that. Here, that the relationship, the personal romantic relationship between Mr. Wade and Ms. Willis began prior to November 1st of 2021, which would be the day that he was hired. That if that communication took place, that is the attorney communication, that the fraud upon the court is Mr. Wade lying under oath about the starting date, and the attorney-client privilege under those circumstances, where that material fact is pierced, and the attorney may be forced to testify to the contrary or inconsistent statement, so that the fraud on the court no longer holds. In our situation, that is precisely what we are trying to do. If this witness's testimony, again, and the court may have to hear some of this ex parte in camera to determine, but if this witness is able to testify that Mr. Wade told him, under whatever the circumstances may be, that the relationship with Fani Willis began before November 1st of 2021, then we know from what the witnesses testified to Mr. Wade that he lied under oath to the court, and that's a fraud upon the court, and the attorney-client communication that specific matter is pierced and needs to go into the record. Now, how best to do that? The only way to do that, if it's not in writing, and apparently it's not, is for the court to hear in camera.
Be cool, y'all. You will get bounced from this stream. I already bounced John Cargus. He was getting weird. Had to go.
You wouldn't pierce the privilege. If, on the other hand, this witness honestly, that is, now we're talking about Mr. Bradley, actually testified to what he has told in text messages to Ms. Merchant on behalf of Mr. Roman, that he
Yeah, hater guy. It's very Socratic with the judge.
Before November 1st of 2021, then he's testifying that his client took the stand and lied under.
This lawyer is articulating what the female lawyer was trying to say, though.
In this regard, the court's going to have to hear from counsel, and that is counsel from Mr. Bradley, and from Mr. Bradley to determine whether or not he actually said what he said to Ms. Merchant, and whether or not it was based on communications, whenever it took place with Mr. Wood.
All right, Mr. Sada, I understand. Thank you for clarifying your argument there. So I understand.
Thank you for that $5 holla, Hader.
Part theory, and what I'd been going back and forth with Ms. Merchant on earlier was that, as I understood, crime fraud applied in Georgia was that the communications had to have been in furtherance of a crime, and to me that presupposes the existence of a crime at the time, or the forming of one at the time of the communications. The theory you're putting forward is one where we go back in time and can reopen that box because it's now become relevant for something completely potentially unconnected to the communications whatsoever. Is that fair?
That falsity has occurred now by
Right.
the very person who is attempting to use the communications as a shield to
Sure.
protect his lives.
Okay.
And when I say crime fraud, it's a fraud waiver that's what Milich calls it, is essentially. I mean, Milich says that it doesn't offend the privilege to ask an attorney to testify to matters already freely discussed by the attorney and a client at another hearing or proceeding. Allowing a client to selectively waive and reassert the privilege as tactics dictates, suggests that the client is using the privilege as a sword and not merely a shield.
So I think it was quite explicit that Mr. Wade never waived anything regarding to communications between him and Mr. Bradley. He was willing to discuss the subject matter, but he was never willing to get into communications that occurred between him and Mr. Bradley. So as to Mr. Sadow's point of this fraud upon the court theory, my question is going to be, has it ever been applied in Georgia?
And the answer to that is, it's not appears to have been applied in Georgia. I cannot find a case in which it has been applied. The cases that I have, the case that I gave you, plus the cases cited in there, are the only thing I've been able to locate. Although I think that the bar rules, if we want to go back to those, that a lawyer lawyer should not allow his client to commit a fraud upon the court.
Okay.
And I think that, along with this, gives the court the discretion to do that. And the only way to make the record, even if the court suggests that this is the law that the court should apply, but even if the court disagrees, there's no way for there to be a record about it unless Your Honor does it ex parte in camera to determine the nature of the privilege, which of course Your Honor knows, earlier days, is how judges can do it with the Fifth Amendment privilege. They can do it with any privilege as long as it's ex parte in camera. So what I'm asking the court to do, because when I get up, I'm going to ask you direct. I'm not going to go through this, what's going on now, to find out whether or not Mr. Wade has ever told Mr. Bradley, in his capacity as his attorney or otherwise, that the relationship started earlier than what Mr. Wade testified to.
All right, understood. So the big takeaway I'm hearing from that, Mr. Sadow, is that once again, we're hearing the words "a matter of first impression" here, and noted. Mr. Gillen.
Yeah, very quickly, Your Honor. Number one, apparently that now he's claiming a privilege, which he certainly did not assert when he was communicating the text with this person.
Sure, but do we have any indication Mr. Wade waived it and allowed him to communicate by that text?
We know what he did. We know what he did.
So how's that an implied waiver?
And I would assume that as the attorney, that he would know whether or not he should protect a communication.
That's a pretty big assumption, right?
Not all communications are protected, number one. Number two, let's not forget how we started on this journey with the state getting up and making very serious allegations against Ms. Merchant, asking for sanctions, saying all of her representations were inaccurate. And now they are doing whatever they can to block access to that information, which shows exactly what she said was exactly the truth. What they're trying to do is they're trying to say to the court, 100% accuracy of Mr. Wade's declaration and of his testimony. And by the way, please, Judge, don't let Mr. Bradley tell you what he knows, because what he knows is that this relationship, based upon what we see from the text and what we've seen in the context, we show that the relationship started before November 2021. So I think we have a waiver issue, and parenthetically on the issue of crime fraud, Your Honor, the issue about crime fraud is whether or not in any context the communication would be not in furtherance of a crime at that time, but it could be for any particular crime committed by the client in the future as well. It doesn't have to be something that's being committed at the time. I will also note that when you look at the attorney-client privilege, the law basically says, look, this is a privilege which blocks evidence from coming in. And so in order to have that, they have the crime fraud exception, which is a very low standard once a prima facie showing has been made, which I believe has been done by Ms. Merchant.
All right, let me clarify one thing, Mr. Bradley. When you testify to personal knowledge, does that include anything you may have seen, heard, outside of communications with a client?
It's hard to say, wild child.
When you say you lack
Maybe,
personal knowledge,
maybe not.
does that include anything you may have seen or heard outside of communications with a client? And you can tell me if that question was horribly phrased. Try again.
You try to rephrase it for me, Judge. I'm sorry.
Okay. When you say you lack any personal knowledge,
Yes, sir.
does that also mean that and include anything you may have seen or heard outside of communications?
Outside of communications with my client.
Mhm.
That's correct.
And communications that were made, if any, that relate to the subject that you were asked to, were there any other third parties present that may have resulted in a waiver of privilege?
Including texts.
Am I answering your question or her question? Okay.
Are there any other third parties ever present with you and a client that would have resulted in a waiver of these privileges?
No, Judge. I can't recall anybody being present. I mean, we ran an office. We had people around our office, but no, I can't say that there were other people present.
All right. And did you ever receive any kind of a waiver from your client at any point?
I have not received a waiver.
And anything that you learned regarding the subject matter at all, if anything, was it in the course of legal advice, of receiving or giving legal advice?
That's a broad question, Judge, to answer, because the advice was given, and then
Important
you have
answer here.
interaction. I mean, it wasn't, hey, this is for, to say specifically, this was for that, or, you know, I can't sit here and say that. So I don't know how to answer that question, Judge.
All right. So
I was given a case that may reflect the same proposition I was arguing from. It's old case. It's Atlanta Coca-Cola Bottling Company versus Goss, Goss. 50 Georgia Appeals 637, appears to be 1935.
Oh, they know the law. They all know the law. Ookie. That's the problem. This is what a hearing that has lawyers cross-examining and directing other lawyers about other lawyers and their relationships with other lawyers. This is all lawyers. This is what a nightmare it can be if it's all lawyers involved in a hearing, which is what this is. All of them are lawyers.
In the case, okay?
It's a very slippery hearing.
As to violations of law or commission of fraud, the protection extends only to communications after the act or transaction is finished. It does not cover communications respecting proposed infractions of the law and the commission of the crime or perpetration of the fraud.
Yeah, I know, Rachel. I thought long and hard about it, but it's such an interesting hearing. I'm just going to have to be very stringent about the no politics debate in this chat. I'm not going to have it, which is nearly impossible. I realize that. Lawyers are sketchy. What is happening?
Called into question the statement.
all right, understood, Mr. State. Mr. McDougall.
Your Honor, this is adjacent Georgia law, perhaps not controlling it. I'll explain that in just a second. That's Rule of Professional Conduct 3.3A2. A lawyer shall not knowingly fail to disclose a material fact to a tribunal when disclosure is necessary to avoid assisting a criminal or fraudulent act of crime. A4, and the reason I would qualify that, since we're talking about candidate report, I need to do that. I believe this rule is regarding the conduct of advocates representing clients.
Are you talking about Jay Shannon, Rachel? If so, I'm excited to connect too.
All right, fair point. Okay, Ms. Trooper, anything you want to address on that?
Or even Shannon L. Any of the Shannons, really.
Clearly,
I love all the Shannons.
But this whole thing is a deductive fallacy. It is suggested that the truth of the conclusion of the argument necessarily follows from the truth of the premises given, when in fact the conclusion does not necessarily follow the premises. They're, called him a perjurer.
Thanks for coming to hang.
He is officially succeeded in saying
a lot of smarts in this room.
True, therefore, we must ask these other questions. And Judge, it's a fallacy. It does not exist as such, and the privilege should still apply.
All right. Thank you all. So I think here is what we need to do. As I understand the law, as I find it, the crime fraud exception only applies when by preponderance we found that communications made in the existence of a relationship or in furtherance of a crime, or the client at the time knew or reasonably should have known that a crime the attorney was being used to further a crime. I don't think that's been established here. Maybe something happened afterwards, and that's something that can be argued during closings, essentially. So I don't think the crime fraud exception covers this. The objection is preserved for the record. Mr. Bradley has indicated also that anything he learned about this subject occurred during those communications. There's some uncertainty on that point. And so in order to preserve the record, at the conclusion of the hearing, I think I can go in camera with Mr. Chopra and Mr. Bradley, and we can put in a sealed filing exactly what the extent of those communications were, if any were relevant. Or excuse me, not relevant, but just what they were, and those would remain sealed until some time if we're ever directed otherwise. However, at this point, the question, getting back to the question asked by Ms. Merchant, as asked, would be sustained on the issue of privilege, the premise. He may have told you something, but it does not appear that there's any evidence that the client ever waived and allowed that information to be conveyed to you. Next question.
Thank you, Judge. All right, let's see. So we talked about Ms. Willis and Mr. Wade coming to and from your office and security details following them. Do you recall that?
Do I need to look at my phone?
No.
Or can I?
Just asking if you
Oh,
recall.
do I recall? I think I did, yes.
Do you recall security taking Ms. Willis to your office?
I'm gonna object to that.
Does he recall
Actually, I
Ms.
take that
Willis
back. No,
taking?
I don't take that back.
You can answer the question, sir.
I do recall security detail bringing Ms. Willis to my office.
Do you recall approximately when that was?
I do not.
And was that on more than one occasion?
I remember 2 occasions.
Okay.
Yes.
Can you tell me about those?
I can't remember when they were.
Were they before she became DA?
So I don't know if she had security detail before she became DA. So, I mean, if she was sworn in, or I don't remember the dates, but I do remember. I think she was DA.
Maybe during her transition team period? Was that?
No, it wasn't. Trying to remember. She would have had to have been the DA, I think. And I don't want to go on, I think. But I do remember twice her coming to our office.
No, this is Mr.
And she
Wade's
had a
former
security team both those
partner,
times.
law partner.
There was yes, she has a security team with her.
And do you believe that it's a different security team than she has now?
I don't know her security team now.
Well, let me ask-
However,
I'm sorry.
I don't know her security team now. I don't know her security team now.
Do you remember telling me that it changed at some point, her security team?
Yes, I think I recall saying that, yes.
And that the most likely people that could testify or had seen things about them having a romantic relationship early on would be the original security team.
I don't recall saying that, no, but
Do you recall talking to me about other people that might have known about their romantic relationship?
I recall.
Yeah, objection based on, we don't know the source. This is either based on privileged information or it's hearsay. Neither one.
It's neither. I asked if you recall.
You need to clarify it. If you're actually going to think, if you think that this draws on information from outside the relationship that we've already he's already testified to, then you need to lay that foundation. Sustained.
Are you aware of other people that you believe would have known about when their relationship began?
I object to the relevance of that. Again, the witness has testified he has no firsthand information of it. Anything he knows about the topic came from representation. Who he thinks might have been able to say something else.
A lot of legal wrangling, not
relevant
much
to
testifying.
And a backdoor to get in the gossip and innuendo that has been pretty much this entire.
All right. Okay, Ms. Merchant, I think we're getting to the point where, you know, the reason I thought this line of questioning was appropriate was to rebut certain inferences about why we were here in the first place.
Right.
But to go into it at the granular level, I'm not.
Good
as
job,
wild about
Fofa.
it. So if maybe you can ask more overarching questions, and if you have anything else you think that's relevant,
Fofa
then
gets a
we
point.
can get to those as well.
Isn't it true that I gave you a copy of the motion to disqualify in this case? I emailed it to you and you read it, reviewed it, and emailed me back that everything in it was accurate, to your knowledge.
You emailed me, and
Okay. All right. So there are things contained within that, Ms. Merchant, which he has now said fell within the
We do
privilege.
love
I
Shannon.
did not have the ability to waive. So I think that's where we
I'm
have to
Team
leave it.
Shannon.
And I believe I still have to ask the questions, and then if he wants to assert the privilege.
Well, I think you've pretty much already established the privilege and the objection has been made, and I think it's a valid one at this point based on the record. So the answer was he did acknowledge that you sent him the motion, and I think we leave it at that.
Let's see.
That's right, Fofa.
And you had knowledge about an apartment. I'm not asking what Mr. Wade told you in furtherance of legal advice, but you had knowledge about an apartment in East Point or a condo in East Point that was owned by someone, and Miss Willis was staying there.
Judge privilege.
I think in the way the question's phrased, she qualified that. So
I did not have knowledge.
You did not have knowledge.
I did not have personal knowledge at all. No,
So no knowledge outside of what is privileged.
that's correct.
Did you have texts between yourself, Miss Willis, and Mr. Wade?
Do I?
Yeah, see, this guy is in a
I
terrible position. This is such a
Maybe once or
weird
twice,
hearing
but-
because it's so personal,
Did Mr. Wade ever ask to use your
right?
credit card?
Yes, Jen.
Correct.
This judge is crushing the game.
On privilege. Same thing.
just asking to use
Yes,
a credit card.
so
how's
much,
that in
yes.
the nature of furthering a divorce proceeding.
Who was talking?
I had a business card, and we would use my business card. The firm would use my business card.
For travel?
Are you asking if I use my business card for travel?
Would Mr. Wade use your business card for travel?
I recall I recall a trip, but I don't know if that trip has anything to do with this case. So I do recall him using my card once.
When was that?
I don't even know when that was, and that's the honest truth. I recall him using my card once, but I cannot remember what that was for. I do remember it was a trip, but I cannot accurately state.
Very
where
little
it was
Carl
and
Banks.
who it was with or anything like that.
And he paid you back for that trip in cash?
I can't remember how he paid. I think it was. I mean, I'm not certain if it was cash or check. We routinely would use my card for filings, for
Oh boy.
paper, for whatever stuff with the office.
But this
And so
Oh, I'm sorry. You're done, sorry.
and so he would whether he paid me back in cash or whether he wrote a
He's a
check.
big cash guy. Big
uh,
cash guy.
You know, it was paid back to the business card.
But this was the only time he had used it for travel.
I cannot recall. I don't even have that business card anymore. But I do recall at least once.
Kind of
for
seems that
travel,
way, yeah.
yes.
And that was when you were still law partners with him, though, correct?
That is correct.
Do you recall approximately when that was?
I do not.
You did not go on that travel with him, though, correct?
I did not.
And so he asked you to use your card for the travel.
Yes, I mean, I'm assuming. I mean, we would use the card for firm stuff, and so it was a business card.
Your business card, though.
It was my business card. Yes,
Right.
the law office of Terrence A. Bradley. Correct.
So it showed up on your accounts.
That is correct.
Okay. Wouldn't show up on his accounts, though, correct?
That would be accurate. Yes.
Do you know if this was before he became special DA in this case, special prosecutor?
I cannot recall.
Did you see he and Ms. Willis together? You said you were in and out of the office, in and out of the
Firm stuff.
DA's office. You saw them together, correct?
In and out of my office or the DA's office?
The DA's office.
Correct.
You saw them together in and out of the DA's office.
Did I see them in and out?
Yes.
Well, if you preface it like that, no. I saw him in and out of the office when I would be there doing my filter work for the taint team.
Right.
He would come by. I rarely saw Miss Willis and Mr. Wade together in the DA's office.
So you brought up the taint team. Let's talk about that for a minute. Tell me about, you did work as, you had a contract as a taint lawyer, correct?
That is correct.
And that was in the anti-corruption unit?
Yes, I think so. Yes, correct.
And how did you get that contract?
What do you mean? How did I get it?
How did you get the contract?
It was,
Bid? Did you apply online?
oh no, it was proposed.
By who?
We were,
Taint
it
team.
was proposed by, I guess it came from the district attorney. I mean,
It's an unfortunate
didn't-
name.
I didn't speak directly with her.
Okay.
It was, with Mr. Wade.
Oh, now
and
he's
he asked if
on
we would be
hearing.
Interested, in having a contract with the Fulton County.
Okay. He
And I
asked
said
you
I
and
would.
Mr. Campbell?
I think so. I mean, I can't recall if he asked us both together or not. Rarely. We all handled several, different things for the firm,
Okay.
criminal, personal injury, things like that. Family
Mandy's the
law.
funniest.
And so
She
rarely
gets
were we
a
together,
hollow point too for being hilarious.
there at the same time, like for an abundance of time. So he may have called me and then he may have called Chris. I can't remember. I can't recall how we got the contract, but
Was Mr. Wade, to your knowledge, part of the transition team for Ms. Willis?
to my knowledge, he was part of the transition team.
Did he spend a lot of time at that office during this transition period?
He did.
So from when Ms. Willis took office to when you left the firm, did Mr. Wade spend most of his time at the DA's office?
When you say most of his time, are you saying just working business hours,
Yeah,
or?
working business hours.
I would say he spent
That may be true, but in a bitter divorce sapper,
I would probably say he
you'd be
spent
surprised how
majority of
petty
the time.
it
If you
get.
say over
It's very
51%,
petty.
I would say yes, he spent over 51% of his time.
And that was the entire time from when she took office to when you left the firm.
I can't say that that was the entire time, but yes, it was majority of It was I can't pinpoint specifically when the time that he would spend. I think if my memory serves correctly, getting to the majority of the time, it would have been whenever he started with this, maybe.
With
That
the
was
as a special prosecutor?
when you say majority of the time.
Right. Okay, so let's talk about the time before he became special prosecutor. Did he spend a lot of time at the DA's office then?
He spent time. It depends on what you say is a lot. He spent time at the DA's office, correct?
And so just so we're clear, you were hired first on January 25th. Both you and Mr. Campbell were law partners, and you were both hired by the DA January 25th, 2021. Is that correct?
Repeat the question, I'm sorry.
You and Mr. Campbell
Yes.
both were hired on a contract basis by DA Willis January 25th, 2021, correct?
Which contract are you talking about?
The first one, the taint contract, not the first appearance contract, the taint
Okay.
contract.
Well, you said the first one, and the tank contract wasn't the first contract. And so,
Okay, so what was the first contract?
to my knowledge, the first contract was the first appearance.
Okay, so let me just mark these. Let's see what number are we on. 23, 24, 25.
The taint contract.
Judge, when they're done reviewing these contracts.
I don't think anybody in this chat would want to be a witness in this case. Anybody.
This rally showing you what's the mark.
This is getting into the nitty-gritty of people's personal relationships. But she held that position. That's the issue. When you're an elected official, you're on the hook. All the money that you spend is public record. I would never run for office. Y'all getting in my shit, digging around in my shit. Pass. Hard pass. Oh, Bob went to Taco Bell 3 times last week. What? It's outrageous. Oh, Bob went to the dispensary 7 times last month. Yeah, thanks, Lisa. Hard pass on the politics.
Okay.
So on now that you've reviewed those, is it true that on January 25th, 2021, you got your first contract as a taint lawyer?
As a taint lawyer, yes, I see the date on that as a taint lawyer, but I'm also looking at this contract here for first appearance.
I mean, she did.
Then,
She came in like a bull in a china shop, which is why they decided not to allow
I
her
don't have
to
it before me,
get back
but
on the
it must
stand
have been a
today.
contract before this.
So you think there's a
She
fourth
came in.
contract?
She was hot.
I-
You know, she was
I can't say that there
Super
is or
defensive,
isn't. What I do know is
super combative,
that we did first appearance during
taking exception to the
COVID.
fact that she was being called out.
and it was before 2021. So I
Oh
don't
my God, the
know,
taint lawyer.
um,
I'm going to get a card. I'm going to go back into
if I had a
practice
contract, a
just so
written
I can
contract
be
at
called
that
the
particular
taint
time or
lawyer.
anything, but I do know, I think that it's, you can look at the recordings because everything was recorded at that time. as to when the first appearance contract started and the taint contract started.
So when the three of you were partners, you had at least 2 contracts to do taint work, which is filter work. And then a contract.
Yeah, the state made the decision not to put her back on, though. It wasn't even Fani or Fani.
Right?
Well,
They're
it
like,
renewed,
ugh.
so I mean, it just renewed.
Mandy, we're
so
going to need a taint lawyer
Yes, I mean, if it
emoji,
was
please.
the same contract,
Thank
but
you.
it was a renewal of the
And
contract.
So how
Oh
did
my
you,
God,
when you
the
said
taint
you got
contract.
these contracts through, Ms. Willis gave them to you, but it was through her knowing Mr. Wade, correct?
Yes, I didn't have a meeting with Miss Willis or anything. It was brought to the attention that a contract was going to be needed or awarded, and if I was interested, because this was off of mine, and I said yes, and so
Mr. Wade brought that to your attention?
he asked if I was interested in doing the contract, correct. And then after that is when Miss Willis, would come in, or I think we actually came down here or something, and signed the contract.
And so that is how you were paid from Fulton County, these contracts.
From Fulton County government? Yes, ma'am.
And you shared your partnership, you shared 1/3 of all your profits with Mr. Wade.
At that time, yes.
And so his contracts, he got a contract that same year, 2021, and he shared 1/3 of all his profits with you, correct?
Yes, that should be fairly accurate.
Okay. So during 2021, 2022, you all had 2 filter taint contracts. You had 2 first appearance contracts, and you had Mr. Wade's special counsel contracts, correct?
My firm had what I have here,
Okay.
correct?
But Mr. Campbell and Mr. Wade were part of your firm, correct?
So we didn't. I
You don't
think
like
at this
taint
time
work?
We had established
It's not a great name,
WBC,
Okay.
but I do want to be
at this
a
time.
taint lawyer.
I think it was. I had mine. Chris had his. Nathan had his, and we operated in the same building. But if you ask me, did we fee share, or without everything that came in? Yes, that is correct.
So you weren't actually partners, you just fee shared.
At this time, well, yes, at this time, we were not. If we were at this time, I had Law Officer Terrence Bradley, Chris Campbell, PC, and whatever Nathan's was, if I'm not mistaken. I'm just.
And all these the taint contracts and then Nathan's special counsel contracts, all of those were under the anti-corruption unit, correct? You can look
First
at it.
appearance was not under that. The taint contract, if I recall, was under the. I don't think they called it. What are you calling it?
You can take a look at your contract if you need.
Okay.
And I'm not asking about the first appearance. I'm asking about the taint contracts
Mhm.
and then Mr. Wade's contract.
That's how my
has already
dad
been
ran
admitted
his
in
firm.
evidence if you
There were
need.
multiple attorneys in there. They shared expenses, but they all kept their own fees unless they were trying cases together. So they all kept their own money, but they did fee share.
Let me know when you're done reviewing.
Well, I see on the first page where it says taint attorney, and I'm trying to go through and I see where it continues says taint attorney, but it always says Fulton County District Attorney's Office. Your question was specific as to the anti-corruption unit, and I'm looking for the verbiage of anti-corruption unit, so I apologize.
No, take your time.
Hello.
And see, on both pages, I mean, it starts out Fulton County District Attorney's Office, and then it just goes to initials FCDA, unless I'm overlooking where it says the anti-corruption unit, then the contract was with the FCDA. I mean, unless you want to show me something.
I'm just asking you, and I didn't know if that would refresh your memory. Those contracts were for the anti-corruption unit, right?
Well, they were for the district.
What do you work for?
I work for the DA.
Okay.
I work for the DA.
Okay. So just in general, the DA.
Correct. I work for Fulton County District Attorney's Office in as a contract person, as it says here.
And
I'm not sure, Ivy.
when you did the taint work, you had to report to Sonia Allen.
I did not.
You did not. Who did you report to then?
I can't remember his name.
Hello, Isabel.
His first name was Brian.
We're a huge fan of you, being a
And,
huge fan of the channel. Thanks for coming.
Let's see. So I know you said you met with Miss Willis when you signed those contracts, right?
Yes, I know I met at least one time to sign these contracts, or to sign when I signed the contracts, yes.
Did you meet with her any other times?
I did not personally meet with Ms. Willis any other time. When you say meet with, what do you mean meet with?
Talk with her, meet with her.
I mean, I would see Ms. Willis in passing if I'm walking through the office and something like that. But no, I didn't have any meetings with Ms. Willis.
Okay, so the only times you met with her were when you
Lot
signed
of
those
taint talk
contracts.
today. Lot of taint talk.
Clarify meet with. I mean, not.
Sat down and had a conversation with her.
I signed these contracts. So when I signed these, I met with her to say that I sat down and spoke with Ms. Willis. Are you saying in life, and you saying during this time? What are you asking me?
I mean, if it's voluminous, I can narrow down the times, but I wasn't.
Ms. Merchant, I haven't really heard a point in a while. Can we get along to something,
Yes,
or we're gonna have to
yes.
wrap it up?
So I had one more question about your text. Have you ever been in any group text with anybody other than, with me and somebody other than Mr. Chopra and Mr. Merchant?
You're gonna narrow that down. I'm sure he's sent many
I
texts.
can look at my
over the course of
phone,
his
but-
So
life.
with him, if there had been any other texts, and I think that the state had some
Him
things in rebuttal they
being-
mentioned.
Yeah,
so I
it's
was
not
trying to bring
murder,
that up so
Blake,
more
but
out there.
it's interesting. It's very
You
interesting.
try the question one more time. for me.
Yeah. Isn't it true that you've
Yeah, this is a lot of, this is quite a bit of
have been
a
between
fishing
me and you,
expedition. I'm curious if they deposed
or me,
anybody
you, and John
before
Merchant,
this.
correct?
These are like questions you ask during a deposition,
Can I look at my phone?
Sure.
not when you're at a trial.
And what's the relevance of that, Ms. Merchant?
They've said multiple times that there's this third party that we've talked to, and I'm trying to establish there's no third party. And I don't know why it was relevant, but the state's argued it, so.
Well, if Ms. Merchant doesn't know why it's relevant, then maybe it might
Okay.
become relevant later, but right now.
Ms. Merchant, I think you've been able to show
Okay.
what maybe launched this and answer the state's initial claims. And so let's get back to the core of what we were here for this hearing. Do you have anything else relevant to ask this witness?
After you, yes, just a few more questions. After it became known that you were placed under subpoena, did you get a call from Gabe Banks?
I did.
And was he trying to determine if you were going to be giving information in this case?
I don't know what he was trying to determine. He stated that it was an odd. I had not spoken to Gabe in a while. We are colleagues. We are friends. We are in the same fraternity, Gabe and I. And when he called, it was out of the blue. But he did call, yes, ma'am.
Okay. And you relayed that to me as well, correct?
I did.
And then you also got a call from your best friend who was relaying a message to you from Mr. Wade, correct?
No, I got a call saying that he got a call, not that a message that was supposed to be relayed to me. The call was,
I'm going to check if there's a hearsay. The response will call for hearsay. Thus far, it hasn't.
Sure. So here's the objection as to the contents of the call, Ms. Merchant.
I believe the contents of the call were to remember your privilege. I took that as a threat. I think Mr. Bradley took it as a threat, and I think he would testify to that.
Aspiring. Here,
Hasn't
I'm going to put it
testified
back
to
up.
He also said there wasn't any message relayed by Mr. Wade or any party.
Well, no, he didn't say it was by any
Right,
party.
Mr. Wade.
So assuming he did hear something from a party, what's the hearsay exception for that, Ms. Merchant?
I believe that it was a threat, so it's a statement against interest. I'm sorry, it's a if he took it as a threat to influence his testimony, then it's not hearsay, then it would be admissible.
All right. So
I did not take it as a threat.
if you're saying it's to the effect on the listener, perhaps,
Yes.
then we'll go from there.
Were you told to remember your privilege?
No, the witness just testified he didn't take it as a threat.
Understood.
Mm,
I'll overrule the objection and the testimony given the weight it deserves.
effect on the listener.
Can you repeat the
I don't
question?
know.
Were you told to remember your
Your
privilege?
Honor, can we-
I was not.
the witness, there may be
Took it as a reminder.
now in the courtroom, is the person that Ms. Merchant is referring to is sitting in the courtroom.
Well, if that witness hasn't been told to testify, then I don't see any sequestration issues.
I don't know who it is. I don't know his
All
name.
right. Okay. And so were you told anything to that effect, Mr. Bradley?
Repeat the question one more time. But so I was not told, remember my privilege.
Something about privilege, remembering that.
I do recall privilege being mentioned, but it wasn't remember your privilege or, a threat of any sort.
But you immediately called me after.
No, I called someone else after.
You called me quickly thereafter then.
I talked to you that day. Yes, ma'am.
Okay. Thank you.
Mr. Sadell.
Your Honor, because this is a defense witness, is it the state's first cross? I think that's how we had been doing it yesterday.
No, actually, we're doing it just this way.
Yeah, I've been.
Okay.
This is
I
the first time
apologize.
he's gone, and then we go through all the defense, and then you'll have your chance.
I don't think the judge seems biased at all. Not even a little bit. I think he's been incredibly
Some foundation
even-handed.
questions to begin with, please. Your testimony as you began representing Mr. Wade as his attorney on what date or what approximate date?
I didn't have an approximate date.
And give me an approximate date when you began acting as Mr. Wade's attorney.
This judge is
I
smart.
would say it was,
Judge knows the law.
if I'm speculating,
I really don't want you to speculate. I mean, you're the one that was the attorney and Mr. Wade was the client.
correct.
So give us the ballpark figure of when it was that you began acting as his attorney.
Maybe 2017, 2018, I think, maybe.
And the purpose for which you were retained.
His divorce.
So, according to you, from that time period, your communications with Mr. Wade with regard to the divorce or any matters related to the divorce, it's your position are confidential, are privileged, correct?
Yeah,
Yes.
but Bambina, he's the one who's
Yes.
making the decision if
good.
she's going to
Now,
be DQ'd.
Did you ever
So
meet
take that into
with
consideration.
Ms.
Because
Willis
if he DQs her,
and Mr.
I don't think you're going
Wade
to think he's biased
prior
then.
to, and everything I'm asking you is prior to November of 2021, okay?
Okay.
Keep that in mind. That's,
Why are you yelling?
I don't think he's yelling, Mr. Bradley. He's just speaking up. All right, Mr. Sadell. Let's
No,
go.
she's not biased. She said
you.
so.
prior to Mr. Wade getting his contract with Fulton County, which was November 1st of 2021. Okay, please keep that in mind.
November 1st of 2021.
Did you ever socialize with Mr. Wade and Miss Willis prior to November 1st of 2021?
I've never socialized with Mr. Wade or Miss Willis in any setting. If you're asking, have I ever met with them, then I would say yes. But when you say socialize, what do you mean socialize?
Have you ever gone out to eat with both of them?
Before 2021, I do not
Or
think
November 1st of 2021?
out to eat with both of them before. When was she sworn in? I'm sorry. When was she sworn in? There was a dinner before, when she was sworn in that I attended. Shaquille O'Neal was there. So it was like her inauguration dinner. So I'm thinking that's before 2021. So I would say yes.
Let's assume for purposes of my question that
Yes, sir.
that's in early January of 2021.
That is early January 2021.
Yeah,
Then,
Fofa, that's a good point.
So yes,
And,
it will be before November.
you know, he's
if
trying
it
to
was
answer
January,
carefully.
Yes, that dinner would have been.
You know, he might not
I'm assuming
necessarily know what
January.
receipts they have.
Okay. And any other time that you socialized, went out to eat, went to anyone's home, you know what socialized is.
Exactly.
Diesel.
So no, I did not socialize with Mr. Willis. With Miss Willis and Mr. Wade.
So prior to November 1st of 2021, did Miss Willis come to your offices? Your offices, I mean the offices that you shared with Mr. Wade.
See, the way I looked at her testimony yesterday, considering
she
it's the
came once or
judge who's
twice
going to
to
make
our
the
office,
decision,
correct.
And the purpose for which she came?
it was at her own peril. He was letting her go at
I
her
don't
own
know. He had
peril
separate
because he's the
offices.
finder of fact in
I
this
do
particular
recall,
circumstance, not a jury.
Well,
I do recall some type of meeting happening at our office, and I don't know what that was about. I wasn't a part of those meetings. There was a meeting. There were other people there. There were other people from I want to say DA's office there, maybe.
Okay, let's go back to the basics. Ms. Willis came to your offices, together offices, on a couple of different occasions.
I recall Miss Willis coming to my office at least twice.
And on at least one of those occasions, or you tell us, did Ms. Willis meet privately with Mr. Wade in his office that you observed?
That's what I'm saying. The judge
Or
is the
her?
trier of fact on this particular
I can't
issue.
recall.
He's the one who's
Can't
going to
recall.
decide if
No.
she's
Did
DQ'd
she
or
ever
not,
meet with you in your office?
not a jury. So,
Ms. Willis.
you know, that's what I'm saying. She was
Privately in my office?
acting the way she was acting
No.
yesterday at her own peril. That's why they didn't put her back
I've
on the
never
stand
met
today.
privately in any office with her outside of signing this contract.
Did
The lady
Mr.
doth
Wade,
protest
prior
too
to
much.
November 1st of 2021, ever talk to you about socializing with Ms.
Hey,
Willis?
alligator. Welcome.
I can't recall.
You can't recall?
You're asking me if he ever mentioned to me that he socialized.
With Ms. Willis, correct.
And I'm saying I cannot recall if he socialized with Miss Will, if he ever mentioned to me that he socialized.
Did he ever mention to you that he ate or went out to dinner with Ms. Willis? Again, time period before November 1st of 2021.
Oh, they can't recall. We're doing better now that
Did
you're here,
he-
alligator.
Repeat your question.
Mr. Wade ever tell you prior to November 1st of 2021 that he had socialized, gone out to eat, visited Miss Willis in anything other than a professional setting?
I'm sure he did, maybe. I don't recall any specifics of any dinners, any specific places.
Yes,
it's
you
been
should
3 years
never,
ago,
ever on direct
um,
examination ask a
the
question
time frame,
that
but
you don't know the answer to.
I do not recall at this time whether or not he
There's
ever
quite a bit
mentioned
of fishing going
uh,
on with this entire hearing, though, because I don't
any
think depth
dinners
took
or
place.
socializing.
Did Mr.
At least
Wade
that's what IV said.
mention to you that he visited Miss Willis at Miss Willis's then current abode, which would have been a place, not her original house, but a place she was staying in the period of 2021 before November 1 of 2021. And his question is, did Mr. Wade ever tell you that he visited Miss Willis at her house?
I don't think I can answer that.
Yeah, the privilege, based on communication with my client.
All right. Mr. State, if you want to try and rephrase the question, you can, but otherwise that would be
Bingo.
On both grounds or just on the privilege ground?
just. I didn't hear a second ground. What
The
would-
hearsay ground.
Oh, that would be on privilege alone.
Did you talk to Mr. Wade at all about his relationship with Miss Willis prior to November 1st of 2021?
I think he's just laying a record, Mr. Wade. It's okay.
I can't
on
remember
those same
yesterday.
grounds, Mr. State Allen, all subsequent grounds, apparently the relationship with Miss Willis in any way is covered by privilege according to this witness.
Well, I think the key words, respectfully, Your Honor, are according to this witness. So I'm trying to drill down to see if there are communications that are not within the privilege.
Sure.
I can,
So then we need to acknowledge the privilege in the form of your question, right?
you're asking me to ask it as in a way saying, are there any non-privileged?
Essentially.
Did you ever communicate with Mr. Wade prior to November 1st of 2021 about Miss Willis that was not privileged?
Wow.
I mean, we discussed this contract, but
This contract doesn't help. You have to give me a
um,
exhibit number, please.
you said before November 2021?
Yeah, November 1st of 2021.
Before November, this contract for 1/25/21 is before that. So, I mean, we discussed this contract.
Okay. And if I remember
This-
correctly, one again, just give me that exhibit number so we can reference it.
Exhibit 23.
Okay, hold on
would have
1 second. 1 second. On exhibit 23, did I understand you to say that it was Mr. Wade that effect brought you and Miss Willis together for the contract?
Beyond the veil, they are trying to
That would be
disqualify
accurate, yes.
Okay.
Fani
And-
Willis, who's the
What did you understand
prosecuting
was the
attorney. She's the one who
relationship
brought the
at that
case.
point between Miss Willis and Mr. Wade?
That's why it's
for
relevant.
Mr. Wade to be able to bring you to Miss Willis for the contract? It's not a hard question. It's
No,
really
I'm
simple.
just, state that again.
Mr. Wade is the one that basically says to you, go see Miss Willis about this contract, right?
Mhm.
That's a yes, correct?
Mr. Yes,
So Mr.
I
Wade
apologize.
had to have some knowledge, you would assume,
yes.
right? That you going to Miss Willis might bring you the contract,
I
right?
never went to Miss Willis. So I stated I never went to Miss Willis. I was told about that there was a potential contract, and that I was asked by Mr. Wade if I would be interested in doing that contract.
My
I never.
Okay, my question to you is, what was the basis that you understood Mr. Wade being able to essentially offer you that contract on Miss Willis's behalf?
I'm gonna object to that. That's a mischaracterization. Mr. Wade offered it to him. I think he said he expressed interest.
Oh,
So
Blake
I
with a
don't
$5
understand,
holla. Thanks, homie.
The relevance of this at all.
So just in terms of relevance or phrasing, I'll overrule on those grounds. So the question is standing unobjected to, Mr. Bradley?
Can you repeat the question?
You've explained.
Closest thing I remember to this thing is the impeachment hearings with Bill Clinton
Yes.
and Monica
My question
Lewinsky,
is,
where they
what
were
was
really
your
getting into
understanding
people's personal
of the
lives
relationship of Mr.
for the whole
Wade
world to
and
see.
Miss
This
Willis
is on a
for it
smaller
to have
scale.
been offered or whatever
what this
word you want
reminds
to
me of.
use, for him to have said, expressed to you whether you had an interest in the contract.
Privilege.
Very
Mr.
uncomfortable
Pettis,
to
no
be on that
further
witness
questions,
stand.
so
I don't
Mr.
care
Senna,
which one of them you
clarify
are.
whether-
Was it a
Very
privileged
uncomfortable.
conversation that you had with Mr. Wade that let you know about the contract?
Or, you know, is the relationship was the question you're focused on?
Is the nature, no, I'm trying to do it in such a way, and I understand what the court said. Was the relationship that I asked you about just now between Mr. Wade and Ms. Willis that gave rise to the contract? Did you know about that relationship as a result of an attorney-client communication?
Yeah, I'm gonna have to peace out.
No,
Go
I
to some
knew
beers.
of that.
Check y'all later.
Through whatever work they did together as municipal court judges. That's
And how did you know that? Who told you about the work that they did together as municipal court judges?
Mr. Wade told me that they did work at some conference.
They're trying to say
Now,
she's
this would have been
conflicted out
something that
of
Mr.
this
Wade
case,
said,
and she's the
according to your
district
time
attorney who
period,
brought
at the
this case.
time
That's
that
why
you
it's
were
being
representing
heard
Mr. Wade,
by this
correct?
judge in the Trump case. She's going to have to deal
Say
with
that again? Ask that again?
ethics issues
Mr. Wade would have
as
told
well.
you what you just told the court after you had established an attorney-client relationship with Mr. Wade, correct?
Yes, but when he told me of them being at a conference, I mean, I'm not understanding how relate. I'm trying to understand your question.
Well, my question is basically, you had communications with Mr. Wade directly that
Yes.
were not
No, thanks,
attorney-client
Galen.
privilege, right?
It was a
I've
great
had conversations with
conversation
Mr.
with
Wade
Nina.
that were not attorney-client
Love Nina.
privilege. Yes.
That involved Ms. Willis, correct?
I just stated that they were at a conference. I don't know whether or not that involved her or not.
Well,
It's a good
if you're
question,
talking
Studi. I don't
about
know.
her,
And
if
it does
Mr.
sound like
Wade
they've
is
mentioned a
telling you
couple
about
times
Ms.
that
Willis and Mr.
witnesses
Wade
are sitting in the
having met at a
courtroom.
conference,
So I don't know why they
right?
didn't ask to
And he's
sequester
talking
the
about
witnesses.
Ms. Willis, correct?
I certainly would have asked to.
Yes, but he also told me about other people
Always
that he met
do.
at the conference.
But he told you about Ms. Willis as well, correct?
I think so. Yes.
So there were communications in which Ms. Willis was at least a topic that was not covered by attorney-client privilege, correct?
This particular instance, I was told about a conference, and
And when were you told this?
I can't remember the dates of the conference, but it was after. It would have been after the conference.
Okay, I'm trying to get just the time period here.
Yes,
After the
alligator.
conference, I want you to understand from the record, I believe we've shown that the conference was sometime in October of 2019.
Okay.
So could you give us an idea, that being a fact, when you would have had this communication about meeting with Ms. Willis at the that is Mr. Wade meeting Ms. Willis at the conference?
If that's the conference that they were at, yes, then I don't know how many municipal court conferences there are. I do know that at the time that I was in the firm, Mr. Wade was he had some position with the municipal court.
Yeah, right now, my only question is time-wise, assuming it's October of 2019, when do you tend to remember? What's your best recollection of when Mr. Wade told you about?
I can't remember because I didn't even remember that it was October 2019 until you said that.
So you don't have a present recollection?
I do not remember that, no.
Had to be before the contract, though, in January of 2021, correct?
That they met?
No, that you were told about Mr. Wade and Ms. Willis meeting at the conference had to be before.
Oh, yeah, yes, it would have been before that, yes.
So what other communications did you have with Mr. Wade about Ms. Willis that are not privileged? We know of one, about the meeting at the conference. Are you suggesting that that's the only one you ever had about Ms. Willis that isn't?
I cannot recall any. I cannot recall.
You cannot recall whether there were any other communications that weren't privileged?
No.
I'll be specific, and I understand there's probably going to be objections, but I want the record to reflect. Did you have a conversation with Mr. Wade prior to November 1st of 2021 about Mr. Wade dating Ms. Willis?
Mr. Wade has risen. An objection is sustained for the record. Excuse me, Mr. Evans.
Say that again.
You don't have to answer the question, Mr. Bradley. Next question, Mr. St.
Well, I understand it's been objected to and the court has sustained the objection. Can you tell us the circumstances in which, that is, under which Mr. Wade may have told you about dating? What I want to do is try to figure out if we can, you tell me if you want me, if I can do this. I'd like to know how the communications themselves took place, where they took place, how they took place, under what circumstance, whether he was at the time providing advice or seeking advice.
Mhm.
So those are the basics. If I can ask as to all those, but if the court's going to sustain the objection to those, then I don't want to waste your time.
And that's something I'll cover in camera. So I'll note the question and your question for the record, and I'll sustain the privilege objection to that.
Okay, all of this prior to November 1st, 2021. Okay? I'm going to show you two text messages. I don't have hard copies.
You want to get it in?
I'm going to set up a question.
Okay, so I'm going to have objections.
Of course, you're going to have objections. I realize that. I want to be able to show it to him, and then I'm going to frame the appropriate question, and then you're going to object. We'll see where we are.
You may, sir.
Look at this text message.
All right, look, can I read it?
Of course, of course.
Okay. Okay.
Okay. Kind of hard to object that, and that's the question.
Yeah, I know it's coming.
Okay, then you must be a soothsayer. Mr. Bradley, I showed you two text messages, correct? Both of those text messages occurred on January the 5th of 2024 at approximately 11:56 a.m. Am I correct?
I think, yes.
Okay. And the text messages would have been between you and Ms. Merchant, correct?
I didn't see it. Yes, it should be.
Okay. And I've shown the same two to prosecution, so we're talking about the same two. In the text message to Ms. Merchant, you indicated knowledge of some activity on the part of Mr. Wade, correct?
I'm going to
I haven't asked him anything about what the,
flag for the court that this is a topic and a specific exchange that Ms. Merchant went into, and there were objections that were sustained.
All right, understood.
Yes.
and it's your testimony that the information that you imparted to Ms. Merchant in these two text messages is based entirely on confidential communications between you and Mr. Wade, correct?
Objection. He's referencing specific knowledge. The specific knowledge comes from Mr. Wade, which we've already established.
Well, the question, he didn't get into anything. He just said, are these two text messages about privileged communications? We haven't actually, I don't see an issue there.
Yes,
And is it your testimony that the knowledge that you have, which you imparted in these two text messages, came from Mr. Wade and Mr. Wade alone? Is that
yes,
correct?
yes.
Can you tell us when it was that Mr. Wade imparted this information to you?
Objection.
All right. And I think that,
That's what you're going to do.
sure. So I'll sustain that on privilege.
And I'm going to introduce for the record, when we finish these two text messages, so that Your Honor has those back there, so that you can,
Sure. What would they be marked as?
what do you have?
I have a whole set. Okay.
I'm going to go ahead.
Oh, the contract.
Once I put a staple in it, I think it'll be Defense Exhibit 26. Yeah, give me a real pen.
All right. So this is marked and made part of the record is Defense Exhibit 26, but not necessarily for its.
This is not admitted
Evidentiary
26.
value.
This is for purposes of the court conducting the in-camera review. And put a staple in it here to make sure that you see.
No, it's free.
All right. Ms. Seda, what else?
All right, so there was also reference, if I remember correctly, to some email correspondence.
What's up,
in which
Laura?
Ms. Merchant sent you the motion that she was going to file to disqualify Ms. Willis and Mr. Wade for your review. Is that correct?
That's correct.
And that was sent to you in an email?
That was correct.
And did you respond to it in an
And the
email?
veil, this guy was Wade's
I
partner.
don't think I responded to her in an email.
Ashley, do we know? You responded by text. I'm sorry, I mischaracterized it. You responded by text?
If I can look at my text, I can, but I'm assuming I did, but
Okay, I'm gonna get it for you, because
Okay,
I don't want
all
there to
right.
be any assumption. As soon as we have it. Let me show you, this is.
Is that what you?
I'm going to show you if I might approach. I made reference to an email that Ms. Merchant would have sent you
Mhm.
about the motion she was going to file. If you look at this, does this appear to be the email that you received? It's dated January the 6th, 2024 at 10:20, 10:25 a.m.
yeah, I see it, the email, yes.
That's the email that you received. correct? Along with, obviously, the attachment, which is referenced.
Yes,
And then, did you respond to that email within the text message that I've just placed before you?
yes, I said looks good.
So the answer is yes.
Oh, yes, I did.
Okay.
I don't know if he was his
We'll
divorce
mark this
attorney.
as
That would make more sense if he
another exhibit
was,
for Your
in
Honor
terms
to
of all
look
the
at.
privilege objections.
Since you love my tone, I have to see it.
If Dizzy was here, she'd find out.
Okay, I'm going to have these marked as 27. Okay? All right, so is it your position that what is reflected, let me hand it to you. Yeah. What's the court's rule? To ask or not?
Allegedly,
We'll
Laura.
take a case by
Yes,
case. I think we're doing
allegedly.
all right, so
That's what we're trying to get to.
we need to ask for this.
It's a painful process.
Is it your position
thank you,
that
Fofa.
your response, which is the second page of the
Forgot
text exhibit
Fofa was in here.
27, is based on a confidential or confidential
Sorry, didn't mean to
communication
forget
that
you were in here,
had with
Fofa.
Mr. Wade?
Do you want me to read the response?
Sounds like you were
No,
right,
I'm only
Beyond.
asking you whether or not the response, you actually already said what it said. I don't want you to read it again. Is that response, based on confidential communication
Thanks, Dane.
that you had with Mr. Wade?
Objection, this is privileged and cumulative.
All right, so now we're talking about the email, essentially referencing the motion as a whole. He hasn't been asked to actually confirm or deny any specifics, just to say whether his response is privileged. So I think we're just laying the foundation, just like we did with the text message. So you can answer that question, sir.
Was my response privileged?
What was your response to the email of Ms. Merchant, which is on page 1?
Mhm.
Is your response, which is on page 2, is that based on knowledge that you received from Mr. Wade pursuant to confidential communication?
This is a very effective cross-examination. This lawyer is effectively working his way around the objections.
Have you discussed with the district attorney's office this case, your purported testimony?
Of my testimony?
Yes.
No,
At all?
no,
No prep, no conversations, no nothing?
no.
Have you given your attorneys, for this matter, did you give them permission to speak with the district attorney's office?
Well, he can assert his own privilege, but that's kind of crazy.
Is there a objection to be heard?
Absolutely, this is
Okay,
privileged.
sustained. Stay down. Next question.
Do you know whether or not your attorneys shared
Fofa.
privileged information with the district attorney's office?
You're up to 3 hollow
No,
points.
I don't know what my attorneys shared or didn't share. I don't know if they even met.
Have you, last question, have you spoken to Mr. Wade prior to today? No, actually, withdraw that. You're no longer in the same partnership or fee sharing arrangement with Mr. Wade, correct?
That's correct.
When did you leave that fee sharing partnership, pseudo partnership
If
arrangement?
his attorney shared privilege
Um,
information, that would waive privilege. That's why he's asking the question.
I don't remember the hard date, but maybe sometime like July, August of 2022, I think.
Okay. And what was the reason for the partnership or the fee sharing arrangements? What caused the separation?
I wanted to leave and go out on my own.
And that's the only reason.
I wanted to leave and go out on my own. Yes.
I understand, but that was the only reason. There wasn't any suggestions
Aw,
or
Meg.
allegations of any form of misconduct on either part, either on your part or Mr. Wade's part, correct?
Misconduct of what?
I don't want to try not to get into the specifics. Is there any allegations made of suspected misconduct on your part or on Mr. Wade's part? That's a fairly simple question. Did he accuse you of doing anything? Did you accuse him of doing anything? Without getting into what it is, were there any
No, Of
accusations
course, it wouldn't
made
be.
by
Not prior to
you or
coming in,
him
you can do
against
whatever you
each
want
other?
to refresh your
We had
recollection
a
prior to testifying.
disagreement. Yes.
And had that disagreement have anything to do with Ms.
Cops are doing
Willis?
it all the
Oh,
time
no.
out in the hallway.
Did it have anything to do with
At
your
all the
conduct?
trials,
No.
Did it have
Wait,
anything to do with
reading
his
the
conduct?
reports.
hold on. Wait. So we had a disagreement. Whether the disagreement
Right,
was
Mag, you got a hollow point. 10 hollow
We
points gets you
disagreed.
guys stickers.
and so we dissolved. Well, I left the firm.
And was the disagreement having anything to do with alleged or supposed misconduct by either one of you?
I don't. If you define misconduct, I'm telling you, we had a disagreement, and
Mod
Just tell me what
hug.
the disagreement was.
the disagreement is mine to know. I mean, I don't see the relevance of the disagreement that I had. It had nothing to do with this Trump case or any other case.
I'm simply getting a question asked. What was the disagreement? It's not privileged, correct?
No, that is privileged.
Oh, it is privileged.
It
Why
is.
is that privileged?
I haven't,
it's
Frankie.
privileged.
I haven't
I
landed
can
on one
tell the
yet.
court
I
in
like a lot of them, though. I like Mahdi's.
camera,
Mahdi's is
but
good.
it was privileged.
Ask a few questions further to see if this is actually something that does fall within that privilege. We can take it from there.
Did it have anything to do with you representing Mr. Wade in any capacity? Excuse me.
It would fall in that line, yes.
But your testimony is that it has nothing to do with your representation of Mr. Wade in connection with Ms. Willis.
As it a connection to Ms. Willis, that's correct.
It's connected to the matter for which you were hired by Mr. Wade?
I wasn't hired by Mr. Wade.
I thought you were the attorney representing him in the divorce.
Oh, I apologize. I thought you were saying something else. Oh, yes. So
Or,
will it
this
apply
hearing
as
is
to
determine
I was
whether
hired
or
during the-
not
Yes, that's correct.
I'm
Fani
not sure what-
Willis is going to be
What this
disqualified
means under that. You
from
kinda got lost on it.
handling
We asked the question.
Trump
not
RICO
relate
case
to your
in
It
Georgia.
did relate to my representation.
In the marriage case.
It does.
The Armada.
And this was
Yeah,
a-
that's pretty good too.
Whose decision was it? At that point, did you stop representing Mr. Wade?
It wasn't at that point, no.
Was it before that?
No, it was after that.
Okay. And how much longer did you represent Mr. Wade in the divorce action?
I'll have to see the divorce proceeding to see Mr. Wade. I represented Mr. Wade for a time after that. He represented me in a construction case for a time after that. And I will have to look at the filings. I ended up hiring new counsel for my construction case. He ended up, but it wasn't right at that moment. It wasn't in a matter of weeks. It was, I don't know.
Continued representing him in connection with the divorce case after you had the separation.
Yeah, Allison
He
Ixnade.
continued to-
Facties.
yes,
She
and
didn't
he
like
continued
it.
to represent me on the
She's the
construction
boss.
But the separation, at least in part, if I heard you correctly, and please tell me if I'm wrong, had something to do with your representation.
I liked
of him in
Facties. She did not.
the divorce case.
That is correct.
Now, Mr. Wade has testified that he did not have a relationship, a personal relationship, a romantic relationship with Miss Willis until sometime early 2022. Okay? I'm leaving that as the premise for what I'm about to ask you. Do you possess information that counters that, that's inconsistent with that?
Any information Mr. Bradley has would be privileged, Your Honor.
Okay, Mr. Seda, I think we've.
Would such information be privileged in your mind?
I think this has already been asked during Ms. Merchant's direct, so we're covering the same ground. I'll sustain
It's
that.
been. Wouldn't have mattered if
So-
she was right or wrong. She's the
I
boss.
can't get an answer to whether he possesses information which is inconsistent
No.
without getting into the information itself.
I think the issue would be.
Now, we're not talking about
Now
the
we're asking
politics
this
of it,
question.
Linda. We're trying very hard. That was the rule coming in.
Of that, and he already answered.
I think the variation Your Honor is referencing whether or not he had.
I
what
think
was
we've kept it
personal
pretty
information,
politic free,
independent sources.
actually, in the chat. So I
Mine is not so
was
limited.
nervous
Mine
about
is,
this because
I'm
it's
asking
an interesting
point
hearing.
blank
That's why I
whether or
wanted to
not
go
he
into
has
it.
information from
I will
whatever
not be
source,
streaming the
including
trial.
Mr. Wade, that is inconsistent with Mr. Wade's testimony.
Because if it includes Mr. Wade, it is privileged communication.
I'm big into women's rights.
Therefore, the
You know anything about me?
If it excluded Mr. Wade, that would be a different appropriate question.
Yeah, moderators for sure. That's 100% on that.
That's it.
Yes.
He already testified he has no personal knowledge.
Unless it's for impeachment at this point, but, Mr. Seda, I think that might be too fine a distinction for me to see the need for the question. I think I'm failing to see the difference.
Well, I'm not asking respectfully, I'm not asking you to see the difference. I'm asking whether I can ask that question and elicit a response which doesn't elicit the actual communications, which is what I'm attempting to do. And if Your Honor says I can't, then I'm finished.
Yeah, Linda, I made that announcement as soon as I started this thing. And I wasn't, this isn't, we're not doing that here
in my mind,
ever.
even confirming the existence of the information goes into privileged communications, whether he does or does not possess information. If it came from that relationship, that's part of the privilege as well. So if I make that clear, then
So you're sustaining what the objection would be.
That's right. It'd be sustained on privilege.
And of course, all the questions that we're
Reserved for the
talking about as far as the foundation about when things are said and what is said, you're going to go into, if I understood correctly, ex parte in camera with the two exhibits we talked about.
That's right. My intent would be to make a record of the knowledge of when it was obtained and the extent of it and the different sources, and that'll be sealed.
And what was actually said.
That's right.
So I guess my question to the court before I sit down is, if hypothetically you learn through this in-camera ex parte examination that the
Yeah,
information
it's interesting,
that
Ariel.
this gentleman has through the attorney-client privilege.
If
is
Cole
in
wasn't
fact
on the
inconsistent with
Delphi
what
case, I would
Mr. Wade
anticipate
testified to under oath.
there would be one of those in
The
that
court
as
is going
well.
to then make a determination of
But
whether it can be used.
they haven't
here,
filed
or
the
whether it
motion
just
for a
remains in the
special
records
prosecutor
and
yet.
sealed.
So my intent would be to make
I think
the
they will
distinction
after that
of,
hearing
from the in-camera
on the
hearing.
18th.
If I still determine that everything is covered by privilege, then anything else that is said cannot go into the factual determinations or credibility determinations that need to be made. And so just the issue of whether the privilege did or did not exist is preserved.
So again, just to follow through to make sure. So if the court knows that there's been a fraud upon the court through the lie of Mr. Wade, none of us are going to know that that in fact occurred, and the court's going to be in a position of making a determination on the motion, even though the court knows that it doesn't have all the information, truthful information.
I'll take a closer look at the case law he provided to see if that is actually a variation of the crime fraud exception. And I'll apply the crime fraud exception as I see it.
Right. And again, I'm not suggesting it is a variation. It is totally separate from crime fraud. It has nothing to do with using the legal advice of the attorney.
But Pink, the difference is in camera
It's you go ahead and commit fraud or
will
lie to
not be
the
on the
court
record,
when you fully
meaning
know
that
someone,
if this
your
gets
attorney,
appealed,
has
the appellate
information
court wouldn't
which
know
is
it,
counter
which is what
and
matters.
inconsistent with what you've testified to.
And to that end, Mr. Sadout, that is something that you can, I mean, I've got this case from Ohio, but if you can find something more on point in Georgia before we schedule
Other
this
than
for
the one I
argument.
gave you,
The Coca-Cola one,
the 1935 case.
the Atlanta Bottling Company. I don't think I went that far. I think it just kind of said the sword and shield language, and it didn't go so far as to say that there's this alternative theory about fraud upon the court. But we can flesh that out in our research.
I appreciate it. Thank you.
Okay, Mr. Stockton,
No question, Judge.
Mr. Durham,
No question, John.
Mr. McDougald,
No question, Your Honor.
Mr. Rice,
Few questions, Your Honor.
Mr. Bradley, you were counsel for Mr. Wade in the divorce case when the interrogatories were initially served on opposing counsel on or about December 27th of 2021, correct?
That's correct.
And you were also counsel for him when the amended interrogatories were served on May 30th of 2023, correct?
That's incorrect.
So you ceased representing him sometime before May 30th of 2023.
That's correct.
At any point during the divorce proceedings, was a pleading filed with the court or a paper served on opposing counsel that purported to have your signature that you were not the one that signed or authorized your signature on?
Say that again?
Did anyone sign your signature without your authorization on any pleading or any other paperwork served on opposing counsel in the divorce proceeding?
I don't think so. If you have the documents, I can authenticate my signature.
And you have testified that you also practice criminal law and divorce law and perhaps other types of law as well.
That's correct.
And are you aware that OCG 16-6-19 defines adultery as a misdemeanor crime in the state of Georgia?
If you say so, yes, sir. Go ahead.
Judge, I would ask the court to take judicial notice of that.
For what relevance?
Judge, I think it does go directly to the crime fraud exception. Because if, before we draw objection, because if Mr. Wade was providing information to him, to his counsel about his intent to either commit adultery or that he was committing adultery, then that would be a misdemeanor crime. It would implicate the crime fraud exception. And additionally, as we know from yesterday's evidence,
Let me pause you there. Isn't adultery as a statute just on its face been found unconstitutional? You can't actually charge anyone with adultery anymore.
It is still current.
Then it can't be a crime.
It is still a current charge.
Let's move on to that next argument.
Additionally, Judge, with regard to the interrogatories, we have 3 different sets of interrogatories that were filed that came into evidence yesterday, 21, May of 23, December of 23, that contain false information. We also have the January of 24 that contains the invocation of privilege. So to the extent that this witness has information, both with the original interrogatories that were filed in December of 2021, and frankly, with regard to the later ones, even though he wasn't counsel, that would be a false swearing and fraud on the court, which again is a criminal offense. And therefore,
It's a good try on the adultery thing. I mean,
Okay.
gotta hand it to him. He's doing some digging. Coming up with some old timey law.
No further questions.
Okay, Mr. Gillen.
Good afternoon, Ms. Bradley.
Good afternoon.
Miss Marple, I see it all the time.
When did
People lose
you
their shit in court
sign your
all the
engagement
time.
letter with
All the
Mr.
time.
Wade to represent him in divorce proceedings?
99% of court proceedings are not televised. You should sit in on a divorce trial. Whew.
It would have to be 2017, 2018. Same time frame, 2017, 2018.
So did you sign
Also known as
or have
Tom
signed an
Arnold.
engagement
Somebody said he
letter
looked like a little bit like Tom
to
Arnold. I'm
represent him,
assuming
or
that's what they
you
were talking
just
about.
speculating?
I can't recall. I mean, we were in a, we shared space. I can't recall if there was a contract or if there is a contract. I haven't.
So Misty,
I
it's a
think
RICO
there is a
trial, so
contract,
all the
but
defendants'
right
lawyers
now
are
it's just
there.
speculation.
So theoretically,
sitting
I think
here,
there's
You do not know whether or
16
not you
plus
had a
Trump
signed engagement letter
defendants, I
with
think.
Mr. Wade.
I think 4
Wade
blood.
discussing the parameters of your legal representation of him. Isn't that correct?
They're not all Trump
That's
lawyers.
not correct.
Bill.
I mean,
It's a RICO
I can't
case.
say I don't have my files or
So
anything with me.
there's
Well,
many
sitting here,
defendants.
you do not have specific recollection or knowledge that you even had an engagement letter to represent him. Isn't that right?
I think I had an engagement letter, but I do not know specifically if I had an engagement letter.
Well, when did you open a file? Did you open when you represent someone, you open a file in your office? And when did you open the file on Mr. Wade?
I am going to object to the relevance of this line of questioning. There has been no dispute by the attorney or the client that there was an attorney-client
Yeah,
relationship.
Miss
So I
Marple,
object to the
really.
relevance of, the circumstances
Divorce
of the
trials are
but,
unbelievable.
And because as Mr. Gillen knows, that's not a factor. There was a true attorney-client relationship.
Well, Your Honor, it's not just up to Mr. Wade.
Very
or
high
Mr.
emotion
Bradley,
running in
it's up to the
divorce
court.
trials.
I agree with you there, Mr. Gillen, and so I'll give you a little bit of leeway, but I don't think we could spend too much time on this.
No,
So we'll
okay.
see.
Your Honor. Now, did you or did you not open a file in your law practice with Mr. Wade's name on it? Yes or no?
Yes, I had a file with Mr. Wade's name on it.
When did you open that file?
I'm assuming 2017, 2018. I can't tell you the exact date. I've said that 3 or 4 times.
Well, let's approach it from another angle. When is the first invoice that you sent to Mr. Wade for your legal
Alligator's
representation?
still working at the nickname game. Like it.
I didn't send him an invoice in that capacity.
So what we have here is you're not knowing whether you even have an engagement letter. You don't know whether you actually even billed him, correct?
I represented Mr. Wade. I signed the documents that we filed. I filed the documents. There's depositions that I had with the divorce attorney that was representing his wife.
Nicotine.
I'm sorry, sir, that's not my question.
Okay.
My question is, did you bill
Missy.
him in your capacity as the lawyer that you're telling him?
I don't recall.
As a matter of fact, did you have any invoices where you billed him on an hourly basis?
I don't recall.
And the answer really is no, isn't it, sir?
I don't recall.
And the reason why it's no, isn't it, is because what happened is that you and Mr. Wade were in a law practice together, and it was a very small work environment, correct?
It was a work environment, yes.
A work environment where you and him would meet and talk literally every day, correct?
Not every day, no.
Well, almost every day.
Not almost every day. I stated earlier that I ran one side of a practice. Mr. Wade did, and we rarely were there at the same time. I stated that earlier today.
So just give us totally how much money you got for representing Mr. Wade in this since 2017 or whenever you told us up until you dropped off the case in 2023.
I don't recall.
Would the answer be zero?
I do not recall.
Well, you would know whether you got paid or not, wouldn't you, sir?
I do not recall.
So you don't recall whether you as an attorney got a single dollar to represent Mr. Wade, correct?
That's correct.
Because you really did it as a friend, didn't you?
No, I did it as an attorney.
Well, an attorney that wasn't being paid. You were doing it pro bono for a friend, weren't you?
I'm going to ask the answer.
All right. So I'm going to sustain that, Mr. Gillen. I think the law is clear that money doesn't even have to change hands for that relationship. I'm making a finding based on the evidence that's already been presented, namely the fact that he signed pleadings, attended depositions on Mr. Wade's behalf, that attorney-client relationship did exist.
Well,
at some point.
I was just laying the foundation to the circumstances in terms of the non-billing from the 2017 period and whether there was really an attorney-client privilege there. That's what I was trying to do.
Okay. If the dispute is just when it occurred, you can try to hone in on that. But the questions I've heard so far are more from you were never paid ever. It's from a overall angle.
Well, from 2017 until November of 2021, you didn't receive a dollar from Mr. Wade for your supposed or your representation of him, correct?
I don't have the file in front of me, and I do not recall.
Okay. And the reality of it is, as I mentioned or asked you a few minutes ago, is that it was a small firm and you were doing him as essentially a favor as a friend and as a law partner, correct?
No, I was representing him as an attorney. Were we in the practice together? Yes. And were we, or are we friends? I mean, we were friends at the time. Yes.
Well, you were friends and law partners, correct?
Yes.
And in a small firm, and I know because I'm in a small firm, people will sit around the office and talk about their social life and what they're doing, correct?
It's up to your crime time.
Correct?
If that happens in your small firm, yes, yes.
Well, that doesn't happen, or did it happen in your small firm?
The witness has been asked very specific questions about conversations about socialization, and we've gone on through it, so I think this is asking it.
All right, I'll let him answer this one question. Overruled.
Repeat the question.
I don't know, Sapper.
Did you in your small firm have occasion to where people would sit around and socialize?
Seems
and
like
talk
that would
about
just
what
be
was
the
going on in
easier
their
answer.
lives, as opposed to merely talking about the law?
Did it pro bono.
Yes.
And
My
you
buddy.
had those conversations with Mr.
I
Wade.
made the horrible
as
mistake
a
of
friend
handling a
on a
ton of
social
shit for my
basis, didn't you?
family pro bono. Ugh. Never, if you're
I
an attorney,
assume
never represent your family or friends. It's a bad move.
Not yet, but it might.
I assume, yes, we talked about sports. We talked about,
I don't think it could.
you know,
I mean, if he signed
sports
his,
a whole lot.
You talked
entered
about
his
life,
appearance on the
figuring out
matter,
what was
that's
going
how
on
I'd
in your
answer
life
it. I
and what was
entered my
going on in his
appearance on the
life, right?
matter. I was his attorney, period.
Right?
Sometimes, very rarely.
Because the
yes,
whole issue is
sometimes.
whether or not he
And
really
that
had
is what
privilege.
you do in a small work environment when you know people very well and you do favors for them, correct?
You're gonna object.
Yeah.
There's
All right.
questions.
Sustained. Next question, Mr. Gillen.
Now,
No, it
in
wouldn't.
that
Pro
capacity,
bono, you have
did
privilege
you,
with your
didn't
clients.
you have
Doesn't
discussions with
affect it at
Mr.
all.
Wade about what was going on in his social life? That they had nothing to do with him asking you legal advice.
Girls, let's talk about
Objection.
girls.
Be more specific.
I think he's just asked whether he socializes outside of legal advice. So I think you can answer that question.
I did answer the question. I said we talked about sports a lot.
Yes, Duty.
And I'm just asking, sports is one
Privilege
thing.
isn't
The
based
social
on
life,
payment.
did you talk about each other's social life, like Mr. Wade, and who he was dating?
All right. So that'll be sustained on privilege.
Your Honor, just for the record, I would state that my objection would be that
William, he
that,
represented him
the
in his
privilege
divorce.
protects
That's where the attorney-client privilege
communications in
comes in.
furtherance of seeking out a legal advice.
Doesn't
not
matter,
talking
they're
about
both
something that
lawyers.
might be
Still have
personal
privilege
and
if he represents him in
confidential,
the
and
divorce.
That's a distinction that I would draw.
I think that's a accurate legal point. However, I think the witness has already.
I did, Galen. I
So,
saw that.
next question.
Somebody DM me that.
You got into the fact.
It
that
took
you
a long
were
time to
the
beat that
initial
cold,
attorney
Sarah.
On the divorce case, correct?
That is correct.
Now, did you and Mr. Wade, without getting into discussions, did you and Mr. Wade together prepare his responses to the interrogatories which were filed initially in the divorce case?
I'm assuming we,
Objection. He's asking about interrogatory responses, preparation of the case in the divorce case. I mean, that's all covered under attorney-client law.
Mr. Gillen?
Well, I don't think it's attorney
Thanks,
client.
Duty.
Did they
Appreciate
meet
that.
together? And when the interrogatory answers were filed, did he file them and did he do that in concert with his client? There's nothing privileged there.
Did they meet and work together, and that work taking the form of them talking back and forth to each other on the right responses?
I'll change a little bit. Did you review yourself the interrogatory responses given in the divorce case?
I did.
And whatever knowledge that you had when you were involved in the interrogatory responses, you had the knowledge of all that material or information that you had without getting into the content.
Objection.
You had all of that knowledge and
Question.
information. I'm sorry, let me get my question out
That's what I
before
was trying to
he
say.
objects. And when you
Good
filed
point
those
about the interrogatories.
you had
Interrogatories
all
are
the knowledge
written
and information
questions
that you would obtain from Mr.
Uh,
Wade
that you use in civil
2017
cases,
up until the
divorce
date the
cases.
interrogatories were filed, didn't you, sir?
Okay, so that's the follow-up question to that is going to be incorporating knowledge learned during communication. So I'll sustain
No, I'm not going to have a follow-up.
It's duty,
question. I just wanna
face
know
the
whether-
fact is.
Whether, is that the case? When he filed the interrogatory forms, he had all of the information that he had discussed with Mr. Wade from 2017 up until the time. That's it. That's my final question.
Okay.
It's all
In which case, without doing that extra assuming link that he based his answers on those communications, it has no relevance.
Well, it does in the sense that it shows what knowledge he may have had when he, the attorney, is filing interrogatory responses. That's what it shows.
Okay. I'm still not seeing the relevance of his knowledge as the attorney filing the responses, unless you're linking this back to
Well,
Mr.
See you, Dr. Bull.
It gets back, Your Honor, to
Hey,
whether or
make sure you
not,
punch Adam
when
Montgomery in
you're
the face
filing
for me.
if you're an
Thank you.
attorney and you're filing an interrogatory response, which you have reason to believe, or specific information to know that certain responses are not accurate, then you shouldn't be filing them. And now, so that's where I was going with that. So if he's got a body of knowledge over here that's built up from his communications with Mr. Wade that everyone so dearly doesn't want everyone to know about, in spite of the allegations made against Ms. Merchant. Now,
So what if the question was, did you, when you signed your name to the interrogatories, did you commit any knowing fraudulent statement and submitting those to the court at the time? Would there be a problem with that statement or that question?
well, I mean, I think that is a conclusion that others could draw, like the court. I just want to know that he had all that information at the time that he, as the attorney, filed the interrogatories. That's it.
We would object. This does fall under attorney-client, and he is making presumptions about when information may have or not have been disseminated to Mr. Bradley in his capacity as attorney. He didn't have to know about anything at the time of, in the middle of, at the end of, or he may never have had that information. There's too much presumption associated with it. The whole matter is covered under privilege.
Modern
One
notes.
comment on that, Your Honor. We have spent
Space travelers.
almost a day talking about trying to block public the dissemination of what Mr. Wade said, either as an attorney or in any capacity, about his relationship with Ms. Willis prior to November the 1st, 2021. And questions about discussions in 2019, all objected to, the claiming the privilege.
Now, if we
And
pronounce my
now to
name the way
say,
they do
well,
in
that doesn't
Italy,
mean
which is
that
mota,
he learned
the
something after.
motivators,
I'm talking about
motivators would be
what
good.
did you know at the time the interrogatories were filed? And everything that now they're claiming privilege, well, that's fine. The court will address that in chamber and in due course. What
Okay.
did you know?
I'm sorry, Mr. Gillen, I really don't see the distinction. So your question's noted for the record and your objection as well.
All right, and I'll follow up with this. Now, you're leaving removing yourself from the case, the divorce case, correct? You withdrew from the divorce case, correct?
Correct.
Did you do that as a result of your concern about any of the accuracies or representations which had been made by your client in the divorce case?
No.
Yes, it
Okay,
does,
So
Missy.
that's going to cover
Mota.
communication.
Trust me, every time I go to Mexico, it's
Well, Your Honor,
big laughs
hypothetically,
for
not saying this is the case.
all my
If,
Spanish friends, my Spanish speaking
Mr.
friends.
Bradley, knowing, let's say hypothetically, that he speaking with Mr. Wade, was aware that the intimate or personal
Huge.
relationship, romantic relationship, existed prior to November the 1st, 2021, and started in 2019 or 2020. If he's armed with that information that he's obtained from Mr. Wade, but Mr. Wade would want to insist on responding to interrogatories which were contrary to the information that Mr. Bradley would have, then I'm asking him whether he took steps as an attorney to say, I cannot be a part of that or countenance that, therefore I'm withdrawing from the case.
Sure. I still see that as covering their communications. So I'll sustain that objection.
All right, well, thank you, Your Honor. That's all I have.
Okay. Thank you, Mr. Gill.
Thank you.
Mr. Kacherov, are you still with us? Anyone on behalf of Mr. Floyd still joining us? All right, moving on. Mr. Cromwell.
Two brief questions, Your Honor. I think everybody's exhausted with this line of questioning.
We're going, Mr. Bradley. When did you withdraw from Mr. Wade's divorce case?
I don't have it in front of me. I don't have the
Can you give
file.
Was it sometime in 2023?
No, it would have probably been, 2023. See, I left in 2022. It could have been anywhere between July of 2022 and maybe December of, it wasn't, I don't have the accurate date, but it wasn't when I left, and it wasn't.
Make it easier. For
Okay,
you.
all right.
You were not his divorce lawyer at
at the time the interrogatory responses were filed in May of 2023. Is that?
Oh, no, I was not. Okay, yes.
And as of today's date, Mr. Wade is still a married man. Would you agree?
I haven't kept up with the divorce proceedings, but I think they're still open.
Okay. So, and if they're still open, that means he's still a married man.
Yes, that's correct.
So if the fact that in a pleading, there is a reference to the marriage is irretrievably broken, that
Well,
doesn't
no,
mean
because
the
he's
marriage
making the
ends.
privilege claim, so he's not lying on the stand.
I guess you have to ask the judge that's handling the case.
He's
Well,
he's claiming
it doesn't end
privilege, so
until
he's
there's
not even
actual
giving an
divorce
answer.
Decree signed by a judge. Would you agree?
I would agree.
All right. Thank you.
Okay, Ms. Cross, were you taking?
I am, Your Honor, and I'm
Sorry.
going to have a minute. My cross-examination might be a long one. So we can go for an hour and a half. I have just a 5-minute break.
Sure. All right, we'll be back in 5.
Yeah, Allie's the poll. All right, so taking a break, and yeah, this is an interesting hearing. I really wanted to stream this one because um, of exactly the reasons that people were talking about in the chat. It's very legally. This is a very legal type argument and hearing. And just so anybody who's joining in late, essentially what's going on is Trump and the other defendants are all trying to get Fani Willis DQ'd, disqualified as the prosecutor in this case. And when they started doing some digging, they found out that she was in a relationship with one of the special prosecutors that she had appointed, Mr. Wade. And then they started digging some more. They issued subpoenas. They got bank records. Once they looked at the bank records, they started seeing that Wade was going on trips with her. So the issue here has nothing to do with the relationship itself, the sexual relationship between the two of them. I mean, they're consenting adults. They can do that. The issue is whether or not she was gaining benefits, financial benefits or other benefits by way of having him be hired as special prosecutor. So, which creates a massive conflict. You know, and the thing is, if the judge agrees and disqualifies her, you know, the question then becomes, because this is a really, really tough case, and I'm just telling you from a legal perspective, RICO cases are very difficult. A RICO case, love him or hate him, against a former sitting president is exceptionally tough. And if she gets DQ'd from the case, the question becomes whether or not another prosecutor in Fulton County is going to be willing to pick the case up. You know, so because there's 2 motions pending. It's the motion to disqualify, and then there's also a motion to dismiss. I don't anticipate the motion to dismiss will be granted, but if this is granted, it basically leaves the case without a prosecuting attorney to prosecute the case. And just because of the tentacles of politics that are all over this case, you know, I don't know how many attorneys, prosecutors are going to be lining up to take this case on. So, you know, it's like coming into wanting to stream this thing because I thought it was a kind of a fascinating hearing yesterday, and I was so worried about. So I want to applaud a vast majority of you for keeping politics out of it. I'm not doing that on my channel, not now, not ever. I don't talk about politics on my podcast. I don't talk about them on my channel. They're too divisive. It's not my thing. So I thank you guys for being super cool in the chat, because for the most part, you guys were pretty amazing. So good job. Because people get heated over politics. It's just a fact. So, so the ramifications of this with the case itself, the underlying case moving forward, is unclear. And ultimately, no matter where you kind of fall with Miss Willis on this, it was very short-sighted for her to hire him or appoint Mr. Wade as a special prosecutor in this case. In my estimation, if she knew that she was in a romantic relationship or was interested in being in a romantic relationship with him, then you don't, when you're trying to take down a former sitting president who is going to be getting into your shit, you have to know that. If you don't know that Trump and his lawyers are going to be trying to do everything they can to undermine the cases any way that they can, then you're foolish. She should have known that he was going to be digging in, that his lawyers and investigators were going to be digging into her. And for her to go ahead and get into this relationship with Wade and then to appoint him. And that's one of the questions. There's a couple of questions. When did the relationship really start? We have testimony from Willis and Wade that it started after he was appointed. We also had testimony yesterday that it started long before he was appointed. So there's an issue of fact there, which the judge is going to have to determine who is more credible. And now I saw people talking about her, Willis's demeanor on the stand yesterday. It was, she was scratching and clawing. She didn't like being up there, obviously. How that's going to play out when the guy sitting in the robe is the one who's going to make the decision here is hard to tell. But I'm sure in his eyes, it probably didn't sit well. It's that whole, the lady doth protest too much type thing. So she got very defensive. And look, I get it. I think anybody in that position who's having their personal lives probed on national TV is probably going to get defensive. So, I just think that there's so much at play here, and without even like really digging into the politics, but all of us understanding that it is embedded, that politics are embedded in this case. There's no other way to look at it. There just isn't. This thing is criminal and political all at the same time. And, if she gets bumped off this case, then there's no way this thing's going to trial before the election in November. No way. And what does that mean in terms of Trump being able to run, being able to be, if he ends up winning the election, it's there's a lot of things at play here. And we just can't pretend that politics don't have a part of it, because they do. They like from both sides. That's how politics work in this country. So, I am contemplating whether or not I want to continue to stream, because if you guys know or don't know, I am jumping on again for another live at 5 my time, 5 Central Standard for a Delphi stream. I haven't been live for the past week. I don't know if you guys follow me on Twitter, but my uncle passed away last Friday. My ride or die uncle. So it's been a rough week for me personally. But I think I'm good to go for today. I wanted to take a test run today. And I'm looking forward to doing that live tonight. And then I'm also I'm taping something with Bill Dorsch with another interview that I'm probably going to want to edit, so we're not going to do that one live. So I'm thinking I'm going to leave y'all on your own to continue to watch the cross. It sounds like there's going to be some more significant cross examination. To me, they're thank you all very much. I appreciate your condolences. I really do. Um, but to me, with this witness in particular, uh, they're going to keep hitting the brick wall. So, because essentially what was going on is he had the privilege claim, because they're trying to get to text messages, which they believe would help prove that this relationship pre-existed the appointment, and he's claiming privilege with it, and he happened to represent Wade in his divorce. Now, in that divorce, and the divorce became intertwined in the case because obviously there were allegations that he was cheating. Wade was cheating on his wife. So that became a thing in terms of them looking at it, and and the question then becomes, well, who was he cheating with? Was it with Willis? You know, so I just anticipate that cross coming up will be a lot more of the same, where they're going to be trying to get at the answer by taking different routes, only to run into the privilege blockade, which it sounds like the judge is going to take a look at and back in chambers. And somebody had mentioned, in a case like this, you can't like you just like there's a presumption with judges that they are not biased, and if he goes back and he conducts an in-camera uh, voir dire of the witness and asks certain questions that will not be on the record, and that's why they're doing it in chambers. Because this is all about. Remember, there's no jury here, so this would be an appellate record that you're concerned about, um, depending on who potentially would be appealing. Um, if she's not DQ'd, I would predict that Trump's lawyers would file a an interlocutory appeal, trying to get that reviewed. If she's removed, she may file an interlocutory appeal. So, I mean, we'll have to figure it out as it goes along. So, I think at this point, I'm probably going to call it. Um, so you guys are going to have to jump on if you want to continue to watch that. I think we were streaming it on CBS. There's a bunch of channels that are doing it. I'm trying to see. I got some sound coming from somewhere. Oh, here it is. Yeah, they're back up and running, y'all. So, I'm gonna end this now so y'all aren't gonna miss anything else. But I love y'all. Thank you for hanging. I know I gave you no notice. I kind of decided to do this spur on the moment or spur of the moment. So, but I will see you. Make sure you come back at 5. It's gonna be a good one. Some more Delphi. You know how I love the Delphi case. It's the case that never sleeps. But thank you so much for all the support. Thank you to all my mods that jumped in with no notice. Once again, terrible about giving my mods notice, and they're all amazing, 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 all of them. And I never mean to forget any of you, Meg. I never do. But thank you for you guys for being in here and taking care of it, because I was putting you guys in the shit today. This thing could have gone sideways, knowing just the politics behind it. And thank you so much for all of the support. Meg, of course, an always giver. Aw, family hug. See, Allie's not here. I could do the family hugs. And Trinity for the $2 holla. Hater with the $5 holla. Blake with the $5 holla. Truth and Transparency, my girl, came in with the $10 holla. Thank you so much. Thanks for dropping in late. Uh, and it looks like Jackie is a new member. Aw, family hug. Welcome, welcome, welcome. We love all the new members. Remember, y'all, like, share, subscribe. It helps, builds the show. Like, share, subscribe, and it's free. You can do it without any money. You can just do it as an act of kindness. All right, y'all. So, as always, without y'all, I just be an old man talking about old and new cases. I'll talk to you at 5 o'clock. See ya.